Yes.
My lord, this is a prayer for a posting, my lord.
Memo for posting.
Memo for
Posting. Posting.
posting, no, after vacation, all met.
One writ petition is, one writ petition PL is for plenary hearing, my lord, because my lord, the
After
area, my
vacation.
lord, no, my lord, in
After
PBMP, my lord, they have left out the construction of retaining wall
After
at the
vacation.
petitioner's
Yes.
residential area, my lord.
Sorry.
If rain comes, my lord, the entire area will merge with full of water, my lord. That's what.
After vacation, get it listed after in second week
withdrawal
after
minutes.
reopening. Yes,
For withdrawal tomorrow minutes. For withdrawal minutes. and
withdrawal. Tomorrow 2:30.
Minutes connected matter at serial number 62 may also be listed tomorrow minutes. We'll withdraw both.
62 tomorrow, together. Day after tomorrow. Day after.
Please.
My lord, serial number 30, kindly be called after vacation. ma'am. Serial number
This one.
30, other side is informed.
In line, yes.
Memo for posting. The
No,
matter was,
after
date
vacation.
was fixed for hearing on
Now
10th
there is no time
tenth
left.
of this month.
No time left. Yes.
Serial number 30, kindly be called after
Yes,
vacation. Other
you
side
want to
is
mention?
informed.
You want to mention?
Yes.
Yes, please.
Serial number 94,
94, yes.
appear for respond number 3. Petitioner counsel is here only,
So what do you want?
Both the matters I appear for the appellant. ma'am.
after vacation,
After vacation,
After
30 and 94. ma'am.
30 and 94.
30 and 94.
Serial number 34, my lord,
My
after
lords.
vacation.
That's unique one.
Serial number 56, my lords. I
56.
appear for accused number 1 and 2, my lords.
After-
Kindly have it after vacation, my lords council.
After
That's serial number
Serial-
89 minutes.
89.
89. It's a batch matter minutes where environmental compensation issues there. Minutes it may be had on any day on at 2:30 minutes because it's a series of matters which are coming down.
But the other vendors have gone after vacation.
No, minutes it may, the petitioners might ask for
Other matters have gone after.
a date. Wherever there's interim order minutes, my date may be fixed after vacation minutes and my request is can we have it at 2:30?
Whenever other matters are listed, it will be listed along with.
My lord,
Yes,
serial
at
number
2:30.
34, my lord, appearing for petitioner.
Yes. Rest matter may come.
That's that.
Compliance is not the.
There's so many matters, my lords. What has happened is, my lords, we don't want to take much time with the mentioning our, my lords. Let a date be fixed. I'm asking even if it's on Thursday, my lords, it's okay. We are okay with it, my lords. The reason is that 89th matter may not reach. That's the reason I'm saying let it have it 2:30. So the entire batch matter can be dealt with. That's all is my request.
But it will go after that. In short, yes. There is already a statement made. The
My
color
lords.
will extend to all men. Color of the state.
Yes.
If not, yes.
Serial number 34, my lord, appearing for petitioner
Serial number
after vacation. 34.
after vacation.
No, we have filed complaints affidavit.
Compliance affidavit is filed now.
Yes, 927. Some compassionate.
Your Lordship, permission to address? Your Lordship, it's an education matter moved in contempt that I require posting, Your Lordship.
After vacation.
Your Lordship, it's education matter because the Tahsildar has not complied with this honorable court's order. The college might cancel my admission, Your Lordship.
Admission to which course?
NLSIU BLLB, Your Lordship.
22nd.
serial number 69, my lord. My lord, serial number 69, my lord. Similar matter is posted on 25th, my lord. It may be taken on same date, my lord.
25th.
At serial number 68, my lord. Or next week, my lord, that writ appeal paper.
A week after vacation.
Speaker.
Serial number 44, kindly have it after vacation. Much.
My lords, this is pertaining to a writ appeal pertaining to labor matter. where the workman is a heart patient as well and he's been denied the benefits of a 17B wages as well.
After which,
Number 36, I request in the next week. Item number 36. We have to file rejoinder, my lord. Rejoinder, we are filing it today.
so what is the request?
May I request in next week? Today I will file the rejoinder. Rejoinder is ready.
We have filed complaints. It is
All
handing
20
over the administration of temple, we have handed.
After which,
Please,
after which.
great. Cell number 51, before other bench. For being spoken to cell number 1, Mr. Prajwal Vishwanath.
Nothing, nothing. I think 2,000. Liberty. No case. His presence. 230. Pull out at 230.
Cell number 2, so HP Gangesh Ruda. Complaint.
Complied with her notice.
Complied. Compliance is done.
No, not yet, not yet, my
Notice,
lord.
notice.
Not yet, my lord.
I accept notice for R4.
R4.
And the direction is against R, in the writ petition against R4 and R6. They are not being made as a parties in the contempt.
Not made part.
R4 and 6 have not been made parties, but the R3 has to send the proposal to
The
the.
party who
government.
is supposed to refund you the amount must be on the record.
Please, I'll bring them on record, my lord.
Leave to
I may
amend
be
the
permitted.
post title by adding
I may be permitted.
original is under 5.
4 and 6.
4 and 6.
4 and
my lord.
6. Full stop. The amendment shall be carried out in the ghost title immediately. Notice returnable on 18th of June.
People obliged.
Only against 4 and 6.
Learned government advocate Mr. Mahendra accepts notice on behalf of 4.
No, and also on 1 and 2, my lord. Notice on.
Why 1 and 2? How they are concerned?
My lord, the R3 has to send the proposal to R2 and R2 and R1 have to fix the pension.
Notice
And
to all.
R4 is only the auditor to audit the,
Yes,
pension.
notice to all.
please, man.
Number 3, PIL matter. Alvin Sebastian.
For the petitioner, my lords.
Yes, you want us to serve the elephant? What is?
My lord, my statement is ready, but my lord, due to inadvertence, my lord, the statement with regard to the death of the elephant is not mentioned.
It died?
Yes, yes, it died. Yes, it died. My lord may have this.
He
My
died.
lords.
The prayer is to attach the collar.
Yes, my lord, when it was captured on 1/7/2023, my lord, it died on 31/10/23.
My lords, if I may make a submission, from June of 23, until December of 23, other than this one wild tusker, there have been 6 other captures made by the Forest Department. I have filed another petition in WP 2406 of 24, which is due to be listed on 19th, my lords.
19th of June.
19th of this month, my lords.
No, in the meantime, when you will file the.
My lord may give me a week's time, my lord. I
My
just
lords,
have to
the
incorporate
statement has
that.
already been filed. I have
11th
received-
June, 11th June. This
I've received their objections on email.
No
already.
urgency, no
It will
urgency.
go to 11th June.
Obliged, my lord.
My lords, if I may request, my lords, the matters to be taken together because it is relating to the same instance
So
of
other
elephant
matters
captures,
will,
my lords.
other matters will keep along with. 11th.
Cell number 4, yes, Venkatesh Prasad.
My lord, I appear for the respondents.
Lord, I filed this application, public interest petition on behalf of the petitioners. Number 1 and 2 are the panchayat presidents, that is Grama Pradhan And
My lord, the matter is being resolved, my lord. The matter is being resolved. My lord, we just have to get a relinquishment deed from the persons who are owning a portion of this road. My lord may have this after vacation and I'll report the.
one submission.
What is the urgency, brother? Your friends are waiting because the vacation is fast approaching.
Please.
So there, where is the urgency in this matter?
One submission, my lord, one submission. Recently, 3 months back, one woman, 36 years woman is died. Because of in golden hour, the ambulance is not.
It is only for your,
My humble.
Mr. Council, only for your benefit, we had asked the government period to take instruction.
My humble
Otherwise,
submission
we
is
are
at
going-
least allow me to interim order to move the ambulance. That's all, my lord. Another Paramanand Katara case will not already one lady is 36 years, lady is died, my lord.
My lord, we are
Another person
widening
should
the
not
road,
be,
my lord.
we will not expect another person, my lord. Because the ambulance has to travel 36 kilometers.
My lord, we are widening the road.
My lord,
Yes,
humble
we
submission,
have-
my lord. They are.
You have said.
Only
leave it.
two-
Yes, sir.
They are kept in tight.
Only
bowel,
two,
at
only,
least oxygen
only
has to
two,
given, my lord.
two options are available to you. Either we pass an order or we keep beyond vacation.
Milord, in this case, the articles 14.
Our learned advocate, Mr. No, now we will not change our stand.
Please, Milord,
Uh,
please,
There is nothing in the matter. We are not here to lay down your mud road. Yes, after vacation, keep it immediately on the reopen. 29th of May,
Obligement.
looking to the
My lord, I will.
aspect that the additional government advocate will be taking instruction to apprise the court about the status of the controversy, put up at 2:30 on 29th of May. You want us to pass the order in advance? Yes.
This is number 5, Mr. Banu Prakash, HV.
My lord, I am appearing for the petitioners. My lord, it's a laying to two-lane bypass highway from Yelburga to Bagalkot. My lord, they have not followed Indian Road Congress, my lord, the guidelines. My lord, this matter had come up before this honorable court. My lord, before Justice Krishna Dixit and the earlier
Page
Chief
154.
Justice. Page 154, the order passed by this honorable court. 152 is it? 152. my lord. Kindly see, my lord. The petitioners are permitted to withdraw. This petition.
We have seen, Mr. Council, there is nothing in the matter. You can't maintain such a public interest petition. Sorry. Our learned senior advocate.
Kindly see, my lord, now the.
Finding out the road and alignment and the width of the road and the alternate road is not the function of the court. And certainly not in the writ petition.
Not the function of the court, I agree with your lordships, but they have, my lord, the bypass road within the city.
Maybe that's entirely executive domain. We are not concerned with that.
Even otherwise, we have held IRC is not justiciable.
No, IRC.
Have held IRC because of Fernandez versus State of Mysore. We have held violation of IRC provisions does not give any coherent cause of action at all. There is such a judgment.
My lord, kindly give me 2 minutes time to, I will convince your lordships. Your lordships have said that you approach this court afresh after expert's opinion in the matter if the ground do exist thereof.
Yes.
Order accordingly. Now, my lord, I have produced the expert's opinion. That's at page 167. Now, the expert has said, who has worked, my lord, throughout in the.
Sir, how court should be in a position to run
Suppose if they
a
have-
race of opinions with the executive?
My lord,
It was Thomas Cooley said centuries ago that the court should not run race of opinions with the executive or the legislature.
what
How
is
can
the-
we do? These are all expert matters. You are also aware of all that.
No, my lord, kindly see, my lord, bypass road within the city, my lord, the guideline says 10 to 40 kilometers away.
Guidelines.
And within the city,
guideline. Yes, it happens. It happens.
It can't happen, my lord. Your
It has
lordship may kind-
happened, it has happened. Two high courts have upheld it, that a road running into mid of the city gives no actionable claim at all. Two high
Bypass,
courts
my
have
lord,
held that.
road I can understand, bypass road. For, see, my lord, heavy vehicles within the city.
It happens.
I will leave it to your lordship.
Yes, Mr.
With liberty to make representation to the authorities.
Again, you will come here.
Then better
That
you
is the
withdraw.
mistake we did.
Better you withdraw.
Number 6.
Petitioner.
Venkatesh.
2 acres of land which was donated to the government for building a veterinary hospital. But the respondent number 3 was MLA, my lords, he makes a request. Government rejects the proposal. But after he becomes a minister, my lord, the land, entire land has been diverted and directed that the hospital has to be closed. My lords would kindly turn to the order, representation of the 159 annexure E1, English translation, where the respondent number made a request earlier.
Earlier it was kept for what purpose?
My lords, it's a hospital for animals.
Now it is school.
No, my lords. Now the person who has made a request, now he becomes a minister in the present dispensation, orders for closure. Government says you can't change the purpose. If your lordships were kindly turn to the page, my lords, the order of the government, earlier government, my lords. Please turn to.
Was there another connected matter?
Yes, my lord,
which we
two
had held?
connected matters.
We
My
had.
lord, where, my lord, the veterinary clinics have been closed and they have been
We keep
shifted.
it together.
Very well.
It is disposed of.
No, my lord,
It's
it's
pending.
pending.
We'll call this matter along with you.
Lords, may I make one request, lords? In the
We have
mean-
rejected interim application prayer in that matter.
But
I
what is-
remember. Otherwise, you have to repeat that order. We have rejected in that matter.
Lords, may I make one request, of course. Lords, let the notice go to R3 also in this matter.
My lord, I
Right now,
take-
we are not inclined. Let it be other with other.
The way, my lords,
Okay,
the things
One
have
for
happened.
note, no. The government advocate will give the number of the matter, we'll list it together.
Very
Then we'll see what to do.
Very.
Yes.
Green bench matters, still number 7. Venkatesh P. Dalwai.
But the petitioner had applied for, my lords, grant of consent for operation. But the respondent, my lords, insisted for issuance of a submission of environmental clearance.
Are you taking any
But it is-
decision or not on this application?
We have taken a decision.
Taken a decision.
We have taken a decision. That's on 19/3/2023, 2024 minutes. We have given a reply to them, pursuant to which they have given other reply to us, for which minutes on 6/4/2024, that is on Saturday minutes, we have issued a letter. May I be permitted to? Yes,
Sir, copy.
We even sent a post. Minutes may have it. But that's the prayer minutes is for positive mandamus minutes. That
Correct.
cannot be granted. For 3 reasons.
Therefore, only we asked whether you are considering or not.
We have so.
But they have not,
We have so. We have the results may turn to minutes. Document number 8 minutes at page number 34. They went there.
The submission of valid DC is a precondition.
Yes, that's the precondition,
Lord,
which is as.
that is
per-
there. That is already there because, my lords, kindly take the order. My lords, the expert annexure J, page 81.
That's, I would want to say one thing, Minutes, that
Wow.
order which they are relying upon has been recalled.
Recalled.
Yes, Minutes, that Minutes I have produced it.
You should have said in the endorsement,
That's we,
you should have said, what you are saying that it is AC is already recalled. Therefore, we are helpless. You will not say all those things. You keep the citizen in darkness.
may make the submission. What has happened is, if fact, after he made a submission to us, that's on CFO, on 19th for 3/2024, we have given a reply. In that, we have mentioned that EC is awaited. Now, that's today they're coming and saying that they're claiming the benefit of Rule 8.
Where is that recall order?
Yes, that's.
Have you made an excerpt to this?
Yes, I have.
An excerpt?
Um, That's my turn to page number 31. Page number 31, that's is what we are able to download from the MOEF website. That methods, the proposal, which if I may explain the tabular column there, methods, at serial number 3, proposal accepted and referred to EAC. EAC method stands for Environmental Appraisal Committee, which is what they're relying upon by an extra D. That methods got recalled on 17/11/2023.
Why could you not say these things in your order? What is meant by reasoned decision? Reasoned decision is a citizen on the street should be able to know why my prayer is not favored. You will not do it every time. We have been saying, you're all statutory bodies. Why can't you say, Mr. Your EC is recalled. We are helpless. You will say everything, all Ramayana, Mahabharata would be written in the order, except what is what. What is meant by reasoned decision?
We ascertained it last week.
You should have told him, you have sent this. Even to convince us you are making argument that recall it was done like this. It is not self-explanatory. A long argument is necessary to understand this. Our question to you is, you are a statutory body of pivotal importance. Why you do not tell these are the reasons why we do not accord the permission? In how many matters this is happening? Every time you argue to understand what is written by your client. That's not the ideal. That we are a welfare state. This is not a Mughal government. We are a welfare state. Therefore, your action should be consistent with welfare, which includes the knowability of the reason why citizen is not given the benefit.
Let's make one submission. Yes, we had to mention that. But here is a petitioner, Millards, who has replied to the orders of MOEF, and then he claims that he has got deemed DC. Millards, may turn to page number 32.
Is there a deeming provision?
Millards, the deeming provision is applicable for prior EC. That is, Millards, any.
Read the section.
Yes, I will. Millards, may turn to the writ petition. Millards.
Page 130. 131, my lords, it starts at Rule
That's
8.
Annexure K, page number 122.
122.
122, relevant portion is at 131.
I'll come to that. May I explain? That's at the bottom quadrant, of page number 122. May I read, minutes? Now, therefore, an exercise of powers conferred under subsection so and so and so of Environmental Protection Act, read with clause so and so of protection rules in supersession, except in respect of things done or omitted to be done before such supersession. So, the central government hereby directs that on and from the date of its publication, the required construction of new projects or activities of expansion, modernization of existing projects or activities listed in schedule to this notification, entailing capacity with change in process or technology shall be undertaken only after prior environmental clearance. Methods I may invite to page number 132. And at page number 123, methods may look at the provision 2, which says requirement of prior environmental clearance. Page number 132 minutes.
Para 9. Which paragraph?
That's page 131 before that. That's the head note of Rule 8, where he's the petitioner is claiming
Roman 3. Roman 3.
Grant or rejection of prior environmental clearance.
Come to 3.
Yes, please. In the event the decision of the regulatory authority is not communicated to the applicant within the period specified in subparagraph 1 or 2 as applicable, the applicant may proceed if the environmental clearance sought for has been granted or denied by the regulatory authority in terms of final recommendation of the expert appraisal committee, that has been recalled.
It's a deed. Which order is recorded?
That environmental appraisal committee's order of suggesting that they are entitled for EC or they should be given EC has been recalled. That is what, my lords, I took my lords to page number 31 of my objection statement. So, my lords, when rule 8.1 is read with 8.4, it says that from the date of EAC's report, 45 days. Now, that's admittedly, the EAC report is a month of November 2023. That has also been recalled on 17/11/2023. That has been communicated to them on 29th of December 2023.
Within the period.
Within 45.
Yes.
No.
Yes. I
45th
can
day
demonstrate
ends,
that.
45th day ends on 25th of December.
It can't.
9/11 is the recommendation. 25th of December it ends. I have pleaded so in my petition, the dates and everything. May I persuade your lordships kindly turn to my petition. That's paragraph 4, page 5. Paragraph 4 of a petition.
The
page
45 days
160.
is to be reckoned from the date of recommendation.
Yes.
Recommendation.
Recommendation, that is on 10/11/2023.
Even then, my lords, it goes to 26th of December.
My second leg of argument is this notification is not applicable to them, my lords, for the reason.
No, first one we will treat. now.
Yes. 10/11/2023, my lords.
Where is
My lords
dated?
will get at my objection statement at page number 31.
When the recommendation expert appraisal.
My lords, 9/11/23, Annexure J, page 81.
9/11/2023.
11/2023, Annexure J, page 81.
Then the orders were made on.
According to him, my lords, orders were made on 17/11. 17/11, that's what he claims, but it is communicated on 29th. That's what my friend has made a statement before the honorable court.
17/11.
17/11 is the
11.
Order is made.
Yes.
That's
When
what he
did you
claims.
communicate it?
No, we don't communicate that, my lords. It's an application pending before the Ministry of Environment and Forest and Climate Change. Now, my lords, the petition industry being a category A industry, my lords, it would fall under MOEF. They have to be the people who have to be looking into it.
Just now he said 29th of December. Therefore, my lord, the honorable Chief
Yes.
Justice asked a question.
That for which I'm replying, my lords, MOEF, the entire EIA notification is not qua the pollution control board, is qua the MOEF.
That's all. We'll come,
Yes.
that is another point.
Yes.
On this first,
Yes.
you rejected it on 17/11/23.
Not me, not as much. The proposal was recalled by MOEF, Ministry of Environment and Forest.
On 17/11/23.
Yes.
When it was communicated to the citizen.
According to the document here, minutes which we were obtained from the website, it was on, a letter was sent on 29th of December 2023.
So that will be after, because Apex Court said, an order shall be deemed to be made when it is duly communicated to the citizen concerned. That's how the Apex Court has structured the judgment in terms of the Lord Linlithgow's judgment.
As of today, minutes, even according to the petitioner's own case and the MOEF website minutes, EC does not, they do not have an EC minutes. Whether they have communicated it within that time or not, that's why I'm coming to my second leg of my argument. Even assuming that, minutes for sake of argument, not accepted. EIA notification which they are relying upon is not applicable to them because they have filed the application pursuant to an OM, that is office memorandum dated 7/7/2021. That's that my lords would get at the application for EC. And my lords, if I may turn, request my lords to page number 81, Annexure J. And I request my lords to page 82, next page.
The argument which my learned friend is trying to make is not found in the order.
Let us see.
No,
He's improving
let's-
upon the
even-
orders.
Let's, if we have to consider, we'll give a detailed order, but then make a submission. At page number 82. That's below agenda number 6, unnumbered second paragraph, minutes, which would start at the project proponent and accredited consultant. That's what we will find.
Yes, sir. So and
So that's the last 3 lines. The said proposal is being appraised by the ministry under violation category as per standard operating procedure issued by Office Memorandum 7/7/2021. Now, my lords, EIA notification of 2006 is applicable to those who have not started their operation or construction or expansion or modification.
Where you will find that?
Yes, my lords, that, my lords, in EIA notification, page number 122, annexure K. Lords, I'll just complete my argument, my lords, before I take my lords to annexure K, if my lords permit.
122.
122 is the EIA notification of 2006.
Where you are ready?
We're ready, my lords, we filed our objections.
No, where is page 122? What you are showing?
Yes, my lords, page 122, my lords, the bottom quadrant, which starts with now therefore an exercise of powers. My lords, last 4 lines. The central government hereby directs that on and from the date of publication, the required construction of new projects or activities or expansion or modernization of existing projects or activities listed in the schedule to this notification, entitling capacity addition in change in process technology shall be undertaken in any part of India only after prior environmental clearance from central government. This is where the aspect of EIA notification being applicable for activities for who have taken prior EC minutes. That's one submission. The Office Memorandum 7/7/2021 has been stayed by the Honorable Supreme Court in a writ petition, which my lords would find in my statement of objection at page number 33.
33.
So my lords, they admittedly, they have filed it under violation category under the OM of 7/7/2021. That, my lords, has been stayed by the Honorable Supreme Court, number 1. 7/7/2021 is the OM, my lords, under which they have filed, which my
But the
lords-
one which you have read now is 14 September 2006.
Right.
Annexure K, page 122. What is stayed is?
What is stayed is 7/7/2021 Office Memorandum, which my lords would find at page number 21 of my objection statement. That's my submission is, my lords, without getting all these aspects, my lords, are known to the petitioner because it has been intimated to the petitioner not by us but by the MOEF, for which he has replied on 4/1/2024. Now, my lords, having replied, they don't concede the fact, my lords, this is a third instance, my lords, before this court, second instance before this court and another court, my lords, which is pending. They have misrepresented to the court, suppressed the fact that they have received any intimation from MOEF or they have replied to MOEF that additional details are sought from MOEF. It's within the knowledge of the petitioner. Second instance, one writ petition, they say that we are not even operating. Then they file undertaking that we won't operate. Please allow, consider it to be show cause notice.
But you could have said everything in that order.
We should have.
Huh.
I am only saying that.
Afterwards, you go on adding these things. What will happen to Mohinder Singh Gill? Yes, you should have said, these are the grounds. Therefore, you are not entitled to. What you will do is after court cases come to court, you go on improving the orders. That we cannot do. That is the bigger
We
philosophy.
have mentioned that at page number 66 of their writ petition on 19/3/2024, we have given a reply to them.
Lords, I claim a notification benefit at 67 by my reply
can't
dated,
claim.
sir, 1 second. By 22nd March 2024, page 67, my lords. The first ground I have raised is that I am entitled for a benefit under 2006 notification. Page 67 is my reply dated 22nd of March.
The one stayed with the apex court is of
No, 2021.
Yes,
they
they have
don't-
applied under 2021.
I am claiming benefit under 2006 notification. Now my friend is trying to improve, saying that this is not applicable to me.
I am not.
But the order.
We'll consider.
It requires consideration. You also go through the objections.
Some date, if my lords, after vacation. Some date.
Or June.
Grateful. That's my objections have been placed on record.
We'll issue, where is Mr. Chaudhary?
Chaudhary,
We are issuing formal notice so
you
that
take
your
formal notice for us because you have filed objection.
notice and your
Because I'm on caveat.
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 And let it
Still you
go
have
to-
to take notice.
Seal number 8.
You write down this much. Learned Advocate Mr. Chaudhary for the Pollution Control Board files statement of objections upon appearing on caveat. Stand over.
I appear for the college, my lord, respondent number 5. Though I stand this side, my lord, I am supporting the petitioner.
You are for?
Though I stand this side, my lord, appearing for respondent number 5, I support the petitioner. My lord. My lord, just to place on record, my lord, there is no examination that is now imminent.
There is no examination.
No, my lord, there is none.
That
So
is
if you are
how,
not-
that is
there
how
is-
we kept it.
Yes, my lord, that is why I wanted to mention. Therefore, my lord, if there is,
But then
I
what-
don't want to unnecessarily put pressure on your lordships unless my learned friend has something else to say. That's of course. I just wanted to bring it to your lordship.
Only the results have to be declared.
That is
That can wait, let us wait. Result
no
of what?
examination. My lord. There is no-
Result of what?
First year MBBS result of the petition, first petition.
That we can do after vacation,
Please, ma'am.
if you succeed.
Third June. Third June.
Little later, my lord, 4 days later,
Choose your date.
after 7th, my lord, any day,
After 7th,
any day.
then 11th June.
The problem was college was absent when we heard this matter.
Oh, I see.
That's the problem.
I'm
And
sorry.
this is how time is wasted.
I
Our time
apologize.
is wasted.
I'll convey it, my lord, today. I apologize.
College may be permitted to take the student the class.
But what is your stand in nutshell?
No, stand, my lord, is that's a bona fide mistake in the name. And in fact, my lord, the medical council in their list indicate the name of the petitioner. There is a bona fide mistake. And on that, my lord, there is a squabble going on.
But your letter on 29th of that particular day
My lord says correctly that this is the name of the petitioner.
is addressed to a wrong authority,
No, my lord, it is addressed to the KEA.
KE.
Yes, my lord, and we have also addressed to the DME.
But then the list will be prepared by the university or KE?
My lord, the NMC, KEA has sent it to NMC, NMC has prepared the list, and the name of the petitioner is found. And there's something, my lord, that I want to bring to your lordship's notice. The NMC, my lord, has not filed any statement of objection. They have simply filed a list of dates and make allegations against the college. My lord, that is a serious allegation that has been made. It can't be done by a list of dates.
Who has made allegation?
NMC,
But we have filed the objection in the connected matter
I don't know.
and
My
then
lord, in
just
this matter, my
pointed
lord,
out the
my lord,
issues which are on
There are
record.
two different things. There are two different set of facts. I'm talking about serial number 68, where I'm a respondent. But where in the list of dates, I have serious objections. In the list of dates, an allegation of fraud is made against us. It is a serious allegation, even an affidavit.
You can take advantage of that when the matter is.
I will,
heard.
madam. I will. I'm just bringing it to your lordship. That's all. I will. I understand. I will. Grateful. Is this seal number 9?
For the appellant's counsel in the first matter, your lordships may recollect, this is where the learned single judge has quashed the appointment of the chairperson of the National Commission for Homeopathy. I appear, my lords, for the erstwhile chairperson is individual capacity. The union's appeal is also connected. Because I hang on to the coattails of the union.
After vacation, you can take.
Third point,
No urgency.
third point is there.
No urgency.
Early day.
13th.
30th, my lords?
13th June.
13th June. No, it's just that, of course, it doesn't lie in my mouth, but right now the commission is functioning without a chairperson. The union may
He is
have,
functioning. Even today he is
He is.
functioning. as well.
but he is functioning.
Because central government is supporting him, so he is continuing.
Without chairperson, why?
My appointment was quashed, my lord, but in any event, I will.
But he is
but
continuing.
The search committee has found him eligible, my lord. He has got the leadership qualities. Therefore, we appointed him.
Whether he has leadership quality or not is the only issue.
Grateful. In the
Connected matters, you have to address office objections. In the connected matter, this side,
our appeal may not be.
you have to look into that.
Still number 10. Syed Kashif Ali.
With my lords, kindly, I appeal for the respondent, please, my lords. My lords, my statement of objections to the IFO stay is ready, my lords. Could I request for 18th, please, my lords?
Can have after vacation?
Yes,
No
my
urgency.
lord, this is pertaining to disciplinary action.
Yes, but
My
you
lord,
can have it after.
matter can be heard and disposed of. my
That's
lord.
what.
Date can be.
19th June.
Grateful to my lords.
Obliged.
Number 11. Shruti Prabhakar.
This pertains to minimum wages writ appeals. We have filed serial number 11 to 25, except 11, 18 and 71 to 78. We have filed further writ appeals, my lord. Today, under serial number 48, your lordships are taking up this matter. These writ appeals also may kindly be linked with serial number 48, my lord.
Can have after vacation?
No, my lord. 48, today it is listed.
Serial number 48 is for a hearing, my lord.
Today it is listed for
Today, how
hearing.
it is possible, you know, the pressure. How many matters are
problem.
posted?
The honorable single judge disposed of, the honorable single judge disposed of the matters
Please.
without the employers who are the concerned parties having been implicated. In every many wages case, when we file petitions, the court insisted, just, I'm talking of just PP Bopana, my lord, his lordship say, implicated the unions first, AITUC, CITU and all this. Here, no employer is implicated, all the 34 notifications have been quashed.
This was in terms of repticos.
Repticos, blood.
And my lords, your lordships have held, it is a legislative power.
You are not legislative.
My lords have held it is a legislative power and therefore it is not a quasi judicial proceedings. If he is a proper party, he could always file the implead applications like other people have
How do I
filed.
know?
My lord, on merits of the matter, we are ready, my lord. Your lordships can take it at item number 48.
The judgment is
Because
passed in
minimum
our
wages
absence.
notification. Minimum
Judgment is
wages.
passed in our absence without implicating us.
No, if it is a
Some of the
legislative-
notifications are 2023.
Mr. Kasturi,
My lord.
the standard writers on the principles of natural justice say these principles are applicable to any action of the executive other than legislative and quasi-legislative.
Here-
Unless the law itself says that you should be heard in the matter.
Here, the section itself provides before issuing draft notification, after issuing draft notification, concerned employers will say representation will be called for. When the legislature itself provides for the employers being heard before issuing of the final notification,
What
when a
happened to the other
notification is
judgment?
being challenged,
The other judgment which you had argued before me went to division bench from that judgment. Do you have copy of that?
The one
No,
that
I-
went up to Supreme Court.
there was idea. Yes.
We have the copy of your lordship's judgment.
Affirmed by the apex.
Cases. There it was different issues involved. There the issues were with regard to the composition of the advisory board. The previous case,
Ah.
which also you appear.
All are arising out of similar orders.
All similar matters.
No, it is
No,
not
sir,
similar.
the earlier batch which was decided was the 2017 matter, which went up to Supreme Court, which related to composition of the board, etc. These matters are different, my lords. These matters
No,
are.
no, the group today
This group
arising
is
out of.
same. All these matters
The
are same.
same, all these matters are same.
All these matters are-
Employers have not been
All
implicated
these
nor
matters are
heard.
same grounds. Same
And our
grounds
notification, which is in a somewhat issued by the government, it may
as
be in
in
our favor,
48.
have been quashed, 34 notifications.
To redo it.
In some of the cases, it has come for obvious objections, that day itself it is quashed.
So you are for the employer,
Of course.
not implicated in the original.
Yes. Not at all.
Not before the learned single judge.
Not at all.
And it can go back.
That's
No,
what
no,
I'm
with
saying.
great respect, my lord, that may not be
Simple.
required.
That's what I'm
That may
saying.
not be required for the reason, the courts have said, my lord, in several decisions, and
2003.
your lordships have also said sitting singly, that the power is legislative. following the BD case, my lord. What is it? Mangalore BD case, Chandra, it is a legislative power. The power exercised by the government gathering information from the sources in accordance with law is to formulate a proposal and receive objection.
Law says that they should be heard in the matter.
There, my lord, before, even there it is not heard. It is a legislative exercise. It is where information is gathered. Therefore, I will show the judgments, my lord. Your lordship will kindly see the judgment of the coordinate bench. Give me the judgment.
Any matter connected to it.
Chandra.
Chandra Bhavana.
Chandra Bhavan and.
But this aspect of the matter, they have said, whether they should be heard or not is not decided. Court said, it is Chandra Bhavana boarding matter, which went to apex court also. But this aspect is not considered, is my view.
Correct.
Your
I may be
lordship,
wrong
my lord,
also.
I
But
respectfully
subsequent-
agree, my
second,
lord,
sir.
that this aspect has not been considered.
Subsequent judgment of the division bench presided over by His Lordship Justice S.R. Nayak said it is not required to be heard, legislative power. It's a legislative power. And it is a legislative power.
What my lord was stating was, you can have, everybody can be heard in the matter.
No, your lordship
And we can request the learned just to have it disposed of in a
Again, there will be one intra-court appeal. Your lordship may hear on the day convenient, my lord, at least let us not go backward and forward. Your lordship may hear, we are ready in the matter. I have come from Chennai for that.
Because the enormity of consequence, why my lord is saying is, the enormity of the consequences, apart from our conventional view of natural justice principles do not apply to legislative, that's one thing. But 17 notifications being struck away by one stroke of pen.
Yes, my lord. I will answer your lordships on that because it was done without reference to the current standard of cost of living. It was done with ignoring the Raptakas bread principle and ad hoc 5 to 10% increase. That was found to be arbitrary.
But we are not on the merits of the
Arbitrary.
notification.
In all the notifications, all the impute notifications, it is ranging from 5 to 10% without reference to the Raptakas bread principles.
My lord, we don't agree with those.
Anyway, we'll fix some date.
Yeah,
so that we can show.
I appeal not for
Because
this.
you are not agreeable to fair proposal which my lord suggested.
The
You can have
parent,
all-
Mr. Counsel, the parent exercise may be legislative, but before learn a single judge, they have right to be heard.
They have right.
That is the only simple thing.
Management.
Notifications being struck off without they being filed.
34 notifications.
34
And
notifications.
what should happen in the meanwhile? If the notifications are quashed, what wages should I pay? It will create problems.
My lord, my
The
sub-
employers are not being heard in this matter.
My lord, they were heard by the original board.
No,
And
no.
My lord, now, if the impugned orders, my lord, if your lordship sustains the impugned order, it is by the board. Whatever information, they can have it before
We
the
will
board.
understand your argument on 30th May.
30th.
But the challenge was before the learned single judge.
30th
We
will
were
be
not
over,
heard before
30th.
the learned single judge.
My lord, 2nd June, my lord, subject to your lordship.
Yes, Mr. Nagana.
I appeal, my lord, for some of the appellant,
Therefore,
for the appellants, my lord. We were, your lordships were kind enough to grant us leave to appeal. And appeals have been filed on the ground, my lord, that we were not heard, we are not made parties there. So, my lord, that is the main contention, my lord. Learned single judge had to hear us.
But you could have made another writ petition seeking review of the very judgment in terms of Shivdev Singh, 1963 Supreme
Yes, my
Court.
lord. I am
Why
familiar
division
with
bench?
that, my lord, that after Shivdev Singh, my lord, some courts have taken the view, my lord, in one case it happened before our High Court only, to say that instead of filing a separate writ, you should have challenged that order itself. So there was some doubt on that, my lord. That's the reason why, my lord, we thought we'll seek leave and file the appeal. Anyway, your
That
lord,
doubt we have clarified.
to
In,
give
October 2023, we
Yes.
have clarified this, we have cleared that doubt also by the division bench judgment, which
Yes.
I am a party. Even that we have cleared. Actually, you can go before the learned single judge and seek review of the order by filing writ petition.
there are other appeals, my lord.
Instead,
My lord,
your
what I-
lordship may remit the matter.
My lord, what I
His
would
lordship
say
can hear
is
us.
save as an
We'll hear it.
It will be a
intra-court,
simple
save
thing.
as an intra-court appeal. My lord, your lordship may have it on 2nd June, my lord. 2nd June,
Fact.
subject to your lordship.
Courts have taken the
June
view
is
that any order
sometime.
passed without hearing in proper
And or
party
3rd,
is a nullity,
any day subject to.
including
First
Justice
week of
Krishna
June, my
Iyer.
lord.
3rd June.
3rd June.
3rd.
In serial number 48 also.
Yes, all.
There's
entire
an
group.
order not to precipitate that may kindly be continued. my lord.
May I make a humble request, my lords? May I make one humble request?
It is listed together.
2:30?
All together.
Anneke?
Maybe in one
series.
or a sequence of same sequence.
Time slot.
Some office objections are to be complied with from the appellant side. Comply. Give that
Could I-
list.
Please. Could I make one humble request, my lord? Could your lordship slot it as a 2:30 matter on that day, my lord?
You can mention and have it pass over.
Now, I'll be ready, my lord. I'll come.
Lordship pleases.
A number of workers are.
The interim order may kindly be continued. It's an order not to precipitate.
Send over to 3rd June at the request of the councils for the learned council of the parties. Interim order operating in the petitions cell, appeals shall continue to operate till the next week.
17, still number 18. Kumar M.
Lord Kumar is on the way. Lord, the appellant, Southwestern Railways, Lord, initiated eviction proceedings under the Public Premises Eviction Act against the first respondent.
Delay of 1,000.
My lord, yes, my lord. Effectively, my lord, this results in delivering a copy which does not exist. My lord, he sought for some document which does not exist. We have now found out that there is no such document.
Copy was not available.
He
Copy was not available.
you know that there is no such proceedings. He gave some random number, the first respondent. There is no such proceedings. Lord, I'll take out notice, my lord, on that.
Lord Learned Additional Solicitor General Mr. Kamath for the appellant. Notice returnable on 19th June.
I'm grateful.
Number 19. 19 to 25. Adjourned. Still number 26. Complaints in contempt matters. Twenty-six. Srimati Shri Rajshekar.
We have filed
Complied.
some complaints. We have issued an endorsement. The direction is to clear the encroachment on the pathway. Not the person who has constructed the building requested to not change the pathway. Not we are considering it and we have issued an endorsement.
You have considered and issued endorsement.
Yes.
Direction was to page 16.
Yes.
Para 6.
Yes, it has to be taken its logical end.
Initiate, you have to take it to logical end. Has it been taken to logical end?
Yes.
What is that logical end? What order has been made? 11/3/2024.
Yes, 13/3. 13/3 is the
endorsement.
11/3 is the not proceedings. Annexure R2, page number 10.
You have asked them to go to the Tahsildar.
No, Tahsildar has taken the decision.
Huh?
Tahsildar.
No, but can you, read second paragraph in Kannada. The translation is not that good.
Which
11, page number 11. The Honorable Court passing the order. Page number 11 is the translation. Starts from 10. The Honorable Court, page number 11, para 2, the Honorable Court passing the order on 22/8/2023 had passed the final order directing to conclude as per the law in accordance with the notice issued on 12/7/2023 by the Tahsildar. In the meantime, Sri Ningegoda and Ramappa having filed the petition for review of the order dated 22/8/2023, the Honorable Court hearing on 1/3/2024, as all the proceedings of the case is to be completed within 11/3/2024. The
Where is the conclusion?
translation is not happily.
Not all right. You come to the Kannada. Kannada makes your case still worse. You have asked them to meet the Tahsildar. Can it be a logical conclusion? What for they should meet you?
May I read the Kannada?
Yes.
ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 22/8/23ರಂದು
But you will make the bench, single judge bench. Because you are reading from Kannada. One of us may not be that proficient in Kannada. That is the reason we insist there should be correct translation of orders.
I'll read the translated.
Yes.
I'll have no house to dwell.
No, come to page 9 of your compliance affidavit.
Please.
Where you see what you are saying is very, very strange things. These happen.
ನಕಾಶೆಯಂತೆ ಈ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ರಸ್ತೆ ಚಾಲ್ತಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಸಾರ್ವಜನಿಕರು ಓಡಾಡಲು ಈಗಾಗಲೇ ಅನುಮತಿ ಮೇರೆಗೆ ದಾರಿಯನ್ನು ಬಿಡಲಾಗಿದೆ.
ಅರ್ಜಿಯು
ಹಾಗೂ ಸದರಿ ಕಾಲುದಾರಿಯನ್ನು ಪಥ ಬದಲಾವಣೆ ಮಾಡಿಕೊಡುವಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿತ್ತು. ಅರ್ಜಿಯು ಪ್ರಗತಿಯಲ್ಲಿರುವುದರಿಂದ
what is meant by that?
The encroacher, since there is no Nakasha road, he requested the Tahsildar that an alternative road has been provided. That is under consideration.
That consideration should have happened. That is the intent of order. How many times citizens should come to this court? Court is not that happy place for citizens.
Now, as of now, the pathway is provided, alternative pathway is provided. Provided.
Where have you stated in your objections?
Here it is, ಅರ್ಜಿಯು ಪಥ ಬದಲಾವಣೆ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಅರ್ಜಿಯು
ಮಾಡಿಕೊಡುವಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು. There is meaning different.
ಈಗಾಗಲೇ ಓಡಾಡಲು ಈಗಾಗಲೇ ಅನುಮತಿ ಮೇರೆಗೆ ದಾರಿಯನ್ನು ಬಿಡಲಾಗಿದೆ.
It's a permissive path.
Yes.
They are saying, give us a way which Karnataka Land Revenue Act mentions. That is their application. Permissive use is one thing. The right of way is another. The Land Revenue Act speaks of right of way. There are two judgments of this court. Where is that consideration? At least that consideration should happen.
A 4 weeks time may be granted,
That's
by which
Then we will dispose of this matter with your undertaking that the whole proceedings would be disposed of in their logical way to an end.
The decision with regard to the alternative way will be taken within a period of 4 weeks.
Decision with regard to
Alternative way as requested by the petition.
30th we'll call this. In the meanwhile, you do it and report.
December 27, Venkatesh P. Delvai.
In the Legal Services Authority, matter was concluded.
It is concluded, certain directions.
It was concluded.
No, my lord, I am
Not concluded.
I'm
No,
not.
there is an order.
It's an order, my lord.
Huh.
Lord, only-
Still you want to prosecute even after conclusion of the proceedings?
No, no, my lord. Only yesterday, my lord, I filed my wakalat in this matter. No objection. In this, we have filed objections also that
No, you admit that Lok Adalat, your matter is concluded. Still, learned judge says it should be, how?
So it is already
Concluded. Admits that.
Who else have you? Anybody?
This one we will.
27th June. Interim order to operate.
December 28.
Interim order granted earlier, shall operate.
December 28.
Short accommodation in the matter. There's some inconvenience, it may be called
But
after vacation.
This is covered by the judgment of this honorable court. All these matters are covered.
Covered.
Yes, my lord. Prior to the 2023 Act came into force, all the application for lease has been rejected.
Lordship, sir, that may not be right. The reason is, there's an application filed, I filed an amendment application. This consideration has to be happened and other matters, the government advocate told he'll serve the copy. I've not been served the copy till today, your lordships. There's an endorsement issued. The endorsement shown is already been covered. I had approached this honorable court and this honorable court has allowed my writ petition. I produced at page number, annexure, page number H1 at 77, your lordships. The said endorsement was issued and this honorable court has passed an order considering my application. Now NOCs are given and NOCs are given. Now NOCs are withdrawn without hearing me. No objection is being granted for the said area. Without hearing me, they issue a notice saying that internal communication has been passed and they say. So I request some time, your lordships, matter may be called. There's an application being pending before this honorable court because there's an order of 2018 which is not served to me till today. Only before this honorable court it is served and I filed an application amendment seeking in the first writ petition. The government advocate told in all other matters it would be served, but till today they have not served the copy to me.
Without disclosing this order, 5th March 2019 order, which I have produced along with the memo.
I've clearly stated I have not been served with a copy, your lordships. In my amendment application, I've told. It's only when the government advocate hands over to me. The irony is, your lordships, all NOCs are given to me after
Without
that.
disclosing this rejection order, produced along with the memo dated, Lord, 21st February 2024.
Is for English translation.
Yes. Page 4 is the English.
So this was done on which date?
2019.
No, 5/3/2023, na?
5/3/2019, your lordships.
5/3
Copy is not served to me till today.
5/3 2019.
But which translation, see that date, what you have written? 5/3/2023, when it is 5/3/2019.
And I filed an amendment application to that effect, your lordships.
Translation.
In translation by mistake, it is mentioned as 5/3/2023 instead of 19. Now, my lord, since the application was rejected prior to the amended Act of 2023.
It's not pending yet.
It's not a pending, it is a rejected application as per.
Lordships, is contrary. I produced at page 71, your lordships. This honorable court has restored my applications. This order is not been served to me. All NOCs are given after that. There's all NOCs. The Deputy Conservator of Forest, the NOCs are given. I produced all NOCs. The impugned order is, they have not served the copy to me. It is without a violation of principles of natural justice. They have not been heard. When this honorable court has already quashed the said endorsement, again passing one more endorsement and issuing all NOCs, which is contrary to law, your lordships.
that stated?
That record I can produce.
No, order should say to whom you have marked and how.
Not the last page of the order. Page number 3. Your copy 2.
Okay. But simple post, you send by simple post or registered?
That I'll have to see. Even then, not challenging this before this honorable court doesn't arise because statutory revision is available to them
Revision.
under 53.
Not been served the copy itself, your lordship. They give it to me, a violation of principles of natural justice.
Now you are served with
Fight-
the copy.
In only
Yes.
one matter they have served,
Now
the
I-
other matters it's not been served, your lordship.
Even otherwise.
Now you are available, we are
Lordship, sir.
copies are.
Revision under 53(3), I have to
Filing
approach.
of affidavit is a formal service of.
Your lordship,
order.
under
Okay,
53(3),
File revision application.
they have only served in one copy, one writ petition, your lordships. In other writ
In
petitions,
all-
copies are
give
not
all
served.
copies.
In
So that-
all the writ petition, we are filing blood rejection
They have not
orders
served me a
today.
copy.
itself.
You have said that, no? About 10 times you have said that.
Today we are filing.
Uh, So they can avail revision remedy and you will not oppose it on the ground that it is not maintainable or it is delayed, etc. These two things she should be.
Blood,
Verified.
if it was served in the year 2019 itself, then they may have to explain the delay. Because
That you have to show prima facie to the court, because madam is saying, we have not been served. Then you have to show, we have sent this, it has reached there.
blood, they have to satisfy the revisional authority, saying that
That question arises only if you prima facie demonstrate these copies, adverse orders were communicated to the citizen. That you have to show by your records.
All are common,
all are come.
so we dispose it of permitting you to.
Not been served with the copy yet, your
Oh,
lordships.
today,
It may be
today
called after vacation. your
Now
lordship.
only I am
give
filing
copies.
all the,
produced in all the matters.
yes.
A copy is not served to me.
I,
today.
Give copies.
I shall do.
It may be called even tomorrow, your lordships. Let me
You
see.
copy what tomorrow, it is covered and you take revision,
copy
he
and
will not
tomorrow-
oppose that
tomorrow-
revision is
Day after tomorrow
not
pass
maintained, he
through.
will not say that.
Day after tomorrow will pass.
Recorded because 60 days, your lordships, 2019.
Blood, based
matter,
on the
your
court
lordship.
order, we have decided all this application.
That is 5/3/19,
Yes, yes. In all the other cases also.
same date.
Same date or different dates.
5/3/19, yes,
All
same,
same date.
Same date.
When we dispose it, right.
53.
15.
53.
The original.
I am filing rejection orders in all the matters.
Page 25.
What is the prayer? This endorsement dated is 20.
Refreshment of endorsement.
What is the 28/12/16?
They withdrawn my all NOCs, your lordships, which are being granted. All NOCs are granted in my favor, your lordships. All no objections have been granted to me to conduct the quarrying operations, your lordships. The irony is Annexure K is that 4/5, if they reject my application on 5/3/2019,
So,
your lordship,
is-
same authority on 4/5/2019 has given no objection. They've recommended for granting no objections to me. Annexure K, page 112. The copy is not served to me. The same authority, your lordships, at 112, Annexure K. The same authority issues granting NOC on prior objections granted to me. That is the reason, your lordships, I require some time to make submissions. If the copies are given to me, I'll make submissions, your lordships. There's some inconvenience today.
That is 4/5/2019 you have issued subsequent to rejection of that one. 5/3/2019 is the order.
Yes, please.
Which you say they should challenge in revision. But come to 112, okay? Page 112.
Where is that order? 26/10, 28/12/16, where is that order? Endorsement.
Endorsement, your lordships, I had approached this honorable court, annexure N, sorry, 1 minute.
Annex A is stated, but it is not available.
Annexure H1, your lordships, annexure H1, page 77, 104, your lordships. The relevant order is at 104. I had approached this honorable court, 104. The said endorsement is quashed, your lordships. It starts at page 103. Accordingly, these writ petitions are disposed of at this stage, disapproving the impugned endorsements if made
Lord,
in
this is
rejection.
112, Lord, is the letter written by the DC, Lord, to the senior geologist.
No, what we are asking is,
Yes.
5/3/2019 is the order. How come that 4/5/2019 endorsement is given?
It is
Please
not,
come to
it is
112.
not an endorsement, Lord. It
Ah.
is a letter written by additional deputy commissioner to the senior geologist who is the competent authority. By that time,
Recommending grant. He was not aware of that endorsement.
endorsement. By that time, competent authority, as per the directions issued by the honorable court, rejected the.
Madam, this is sent by additional district magistrate, the deputy commissioner. But how he will know that on 5/3/2019?
It's to the senior geologist, your lordships.
No.
Even it is to the senior geologist. Competent
Correct. It
authority
makes
is
no
senior
sense
geologist.
because it is only recommendatory authority under the scheme of 1994 rules. He is only recommendatory authority. He did not know that on 5/3/2019, a coercive order is made against you. How he will know?
At least after 34.
No,
your
that
lordships.
makes no sense.
I'm only saying after 34, it is addressed to senior geologist. Senior
makes-
geologist is the authority who has passed on 5/3/2019. He could have communicated, but all NOCs are granted by the deputy commissioner, your lordships. All NOCs are granted by the deputy commissioner and by the senior geologist. On the recommendation of the senior geologist, only the NOCs are being given, your lordships. And if the order of 5/3/2019 was there, the senior geologist is the authority who has passed the order. He could have communicated to the deputy commissioner that no NOCs cannot be given. But in this
But in
case, all
any,
NOCs are
in
given.
any case, you have to challenge this 2019.
Yes, your lordship.
So you go before revision also, you didn't challenge
Yes, your
it.
lordship, but under 53(2), I have only 60 days. Limitation is there, your lordship. So limited, if I
Let me
file it
Now,
now.
sent the orders to them.
Yes.
How it was sent? How the orders were sent? Or you passed order and kept it in your drawer?
I've specifically communicated in the first petition.
Why
I'm not being
can't you
served.
be little slow? You are spoiling your case.
Sorry, your lordship.
Well, how it was sent? When it was sent? Because I think in Pedareddy, the division bench of this court said, passing order means passing order and communicating it to the mine aspirant.
Please.
Where has that happened? Otherwise, how they should go for the revision when statutory period is limited?
I shall place all those material.
You will forego that you will not raise
No,
any
no, no,
limitation.
because revisional authority do not have a power to condone this.
Therefore, we are telling you,
Please.
if you pass an order and keep it in the drawer, these are the words of the division bench.
My submission
I'm
is.
only reproducing them.
Now, my submission is, Lord, I shall produce all those records for,
So that they
to
were-
show that when it has been sent to the.
Instead, what we were thinking.
We'll say that the pursuing this petition will be bona fide, litigating bona fide. And if that question arises about limitation, this will be treated as bona fide.
Otherwise, they will be put to enormous injustice.
Lord, even in the direction of this honorable court, there is a time-bound direction to decide within a period of 6 weeks.
The question is, since you are not demonstrating before us that the citizen was informed of this order, we sent it by post, muddam, whatever. Now you are producing it now. Other, if we say, this is the order, you challenge it, where they should challenge? Because it's a time-bound revision.
That's true.
No provision for condonation of delay also. That's all courts have said.
If your lordships are relegating the matter to revisional authority, then Lord, we may be permitted, the competent authority may be permitted to produce all such document to show that Lord, it has been served. Then let the revisional authority decide on the.
It is possible, show us on 22nd.
On 22nd, you just,
Please.
otherwise they will be put to enormous injustice. They will not have right of revision at all.
I shall produce all those.
22nd, 2:30. All entire group,
22nd April. 22nd April.
Monday.
I have filed, my lord, all the rejections.
Show us that the orders were sent to them.
How many matters are there? 8, 9 matters.
Five.
of them.
5 matters.
5, 6.
Copies are served.
Number 29. Chandrasekhar Reddy, RA.
Presenting the appellant in item number 29, my lords. The appellant in item number 29 died on 23rd of January 2024. The wife and children of the appellant have made an application seeking your lordship's permission to come and record in the case, as is legal has.
Appellant is dead.
Yes, ma'am. In item number 29, writ appeal number 322 of 23, he died on 23rd of January 2024. Your lordship would get the death certificate at ink page 6 of the application. The first applicant is the wife. Applicants B, C, and D are the children of the appellant.
So LR application is filed on demise of the appellant. Mr.
Yes, ma'am. On 21st of February.
One last matter, my lord, it is public, this has been filed by public.
That's all right. Any objection to, or can we allow this application?
No.
We'll allow this application.
IA 1 of 24, heard learned counsels for the respective parties. Filing this application. This trade is to permit to join Harrison legal representative. Named Muni Raju Reddy, who died on 23/1/24. Death certificate, copy of the death certificate. Producer report, evidence is the death of the appellant. The heirs and legal representatives of the deceased appellant. Take the name from IA. Timothy, take the name. Age लिखने की not necessary mention. It was submitted that the heirs are entitled to continue with the cause of the deceased appellant, and therefore they are entitled to be, therefore they are required to be joined in place of the appellant. In capacity of. Correct. As could be seen, the heirs are the wife, daughter, and two sons of the deceased appellant. It was given out that there is no conflict of interest among the heirs proposed to be joined. Paragraph. In these circumstances, the application deserves to be granted. The heirs above name of the appellant are permitted to be brought on record. Incapacity of the heirs of the appellant, whose title shall be amended accordingly.
29.1, the same appellant is the respondent number 8. I have already filed an application, 1/24.
So I'll.
29/2, my lord. Also, we are also filed an application to dispense the notice to the respondent and filed an IA on 25th March 2000.
No, 29.1, the appellant is the respondent,
Respondent number 8.
and you have filed the application.
I have already filed.
So that application is allowed in the same way, but the.
And in
29/2, my lord.
You are same person?
Yes, my lord. We are also filed an application for dispense the notice to the respondent because the respondents also petitioners in other petitions.
They're here.
Yes, my lord.
In 29.1.
No, who represent them?
I am for the petitioner, my lord.
That's all right. The respondents here, you said
8, 9, 10, 11, 18, 21,
appear
22,
for them?
25.
Your authorities. You appear for whom? Mr. Vinod Prasad.
I appear for appellant in the last batch.
Same respondents? No.
No.
Then notice has to.
They are grantees. We have challenged the grant in their favor.
No, we are asking. Your friend said that some of the respondents are represented by this side. So that we can dispense with notice. If you are representing the deceased, the LRs of the deceased, you represent them.
Only in one case I appear for them. In none of the cases they are made us apart.
In which case you represent LRs of the deceased Miraju Reddy?
No, he doesn't appear
No,
for any one of
you do
them.
not. Then notice has to.
No, madam. Yes, respondent 8, 9, 10, 11, 18, and 21, 23, 25, my lord. So other writ petition kindly sees writ petition, writ appeal number 309.
They are the appellants.
Yes, my lord. Radhakrishna
Who
Reddy.
appears for them in appellants?
My lord. In writ appeal 309.
Brother, we are asking simple question. For those appellants, who is the counsel appearing here?
I don't know, my lord.
Lords, I am appearing in 29.3 minutes. I'll make a comparative chart and then give it to your lords minutes because there are so many overlapping matters. There are about 7 matters minutes which was decided by the common orders. About 5 writ appeals are filed. Minutes, as the learned friend said, minutes, that there are common parties in all the matters. I'll file a chart minutes of all the parties and their corresponding ranks in the respective writ appeals.
That will help us.
I shall do that minutes. I shall do that. I've instructed the council on record to do that.
Can we have this matter after vacation?
Please, minutes.
One submission.
Interim order.
It's an order of status quo, my lord. The work was already started by the BWC.
No.
It's already under progress. Nearly about 350 crores project, 110 villages, water is to be. My lord, this matter.
Under, it is section 73 order.
77. This land has been allotted to us, my lord, and it's already position has been given. And subject to the result, my lord, let us go on with the work.
It's not a case of acquisition. It's a case of execution of work on the private
Execution
land.
of work.
And that is allotted during the pendency of the writ petition and the appeal for regular first appeal before the lower court.
No, that's all right. But it's a statutory power.
Yes.
No, my lord.
How it will come in your way.
No, if they have executed the project, then I will lose the land without any compensation.
No, for that there is a separate scheme.
27. Yes,
Read
but
the section.
May I make a submission? Lord? I appear, my lord, in 29.1. In 29.1, my lord, I appear for the appellant.
Yeah.
Lord, our case, my lord, is that this land was granted to us in 1975 by the.
We'll assume that you are the owner of the land now.
No, my lord.
It's not a case of acquisition. That's what division bench said.
No, Inam Abolition Act, a grant is made in my favor.
Correct. But
About
how that
30 years
come in the
later.
way of execution of statutory power for providing the amenities?
No, my lord, what they are doing, what the contention of the state now is that order of 1975 is cancelled by this order of 2020.
That will examine.
Ignoring.
That will examine, no issue, absolutely no issue.
But today, my
how
lord,
can you halt the work of the statutory body.
No, my lord, if the government grants, my lord, land which is not belonging to it to somebody else, that is what is an issue now. My lord, it is ultimately, my lord, the grant made in my favor. If that has to be set aside.
Lords, may I just add this to what, sorry.
77.
Section?
77. My lord was pleased to pass an order in this similar matter, my lord. And that was confirmed by the Supreme Court also, my lord, your lordship's order. My lord, what my.
Do you have that order?
But I filed it, my lord. There's some communication. I'm sorry, but the files have. Temporary.
Use the right to use.
Right to use.
Right to use.
Use that.
With compensation.
Yes.
Section 27 is only an enabling provision, my lords. It does not vest the power of eminent domain. Lords, it is not the power which is similar to Section 16 of the Electricity Act. Lords, it's only an enabling provision, my lords, which permits them to exercise certain powers under the scheme of the statute. Lords, may I just say this, my lords. The BWSSB claims the land is granted to them by the government and therefore they want to implement the project. That is essentially what they are contending. They are not relying upon Section 28. It is not their case, my lords, that this is a private property over which we wanted to execute the works is never their case. Not this was an interim order granted after hearing, my lords.
Do you have that copy of the order?
Pass over, my lord. I got everything, my lord. The file has been on. Some of the files.
So if your lordships is considering modification of the interim prayer, may I request your lordships may have this matter on Thursday or on Monday, my lords. I'll assist your lordships with the necessary provisions.
That judgment also.
Please.
In my. You can take it immediately.
19th?
Very well, lords.
19th, yes. In my appeal, there is a deal of 120 in file.
Are they served in that? Who appears for respondents?
Respondent, they served a copy. They are the petitioner in the writ petition, only 4. And the other respondent is Mr. Sandeep, BWSSB.
But notice has to go to private respondent.
The advocate is appearing on their file wakalat.
Who appears? Identify which of them will appear.
The pass list shows their name. Pass list shows their name.
Give us
The
chart.
matter is
these
referring
things.
to, I am unable to.
Then file it. Give chart which Mr. Ravi Shankar said. Mr.
Lords, I shall do
Nagesh
that,
can
lords.
give Mr. Nagesh and Mr. Naganand. Let Ravi Shankar give the chart of persons who appears for whom, so that we can make the order on the next day.
In the meantime, my lord, I'll also produce all this judgment. I'm sorry, my lord.
Give that judgment.
19th.
Lords, interim order is to be extended, my lords.
19th. Interim order.
Urgent, still number 31. Non-filing in complaint, contempt matter. So Basaraj Reddy.
I appear for the complainant, my lord.
For accused number 1 to 3, my lord, we have completed the order, my lord. But sorry, my lord, I could not make the translation copy.
29.
31, my lord.
31. You are compliant with the order. Have you shared a copy of the order, compliance order?
Lord, I have received it now. The
That's all.
only, no, my lord, I have a submission to make. My lord, this is a case where in the reply to my representation, they state that my property is not mine and it belongs to the government, etc. But my lord, there are documents to show that the subject land in question was proposed for acquisition a few years back, and my,
They have considered, they have made order. You should challenge whatever order.
my lord,
you have
may I
passed
be
on.
permitted to file objections to this, please, my lord?
In contempt proceedings, it is unknown. Many are telling like that. We are examined fully. It is absolutely unknown.
My lord, please
They
see
have-
page
they
number
have
4
passed-
of their reply, my lords. My lords, this is a case where we are the owners of few lands and our property.
Consider the representation. That was the order. If you are aggrieved by consideration, it appears to be wrong also. You challenge it. All
My lord,
contentions we keep open.
my
We will
submission-
not, critical examination of the orders of compliance will not be examined will not be undertaken in contempt jurisdiction. That's how we have held, subject to exceptions, into which your case does not fit.
My lord, prima facie, may I show in their reply itself, my
It's
lord?
only for compliance.
Compliance,
contempt
that's
jurisdiction.
rightly or wrongly, they have done
Nothing
that.
more. Any merits we can't look into. You file a substantive proceeding, independent. We'll
My
resolve-
submission, my lord, is that they have filed this reply only in order to say that we have complied and making us
That's the end of
run
the
from
matter.
pillar to post, my lord, because prima facie in the representation itself,
Why can't you
there is
read
a
some good
contradiction.
book on contempt jurisdiction? See what Apex Court said in GL Gaba. The critical examination of the orders of compliance shall not be undertaken by the contempt court. That's the law, more than 60 years. To challenge, all contentions will be kept.
May I bring to my lord's notice at least
We'll note your argument also.
their reply itself says that they have paid us compensation when our lands were submerged, my lords.
By filing this contempt petition, the grievance of the petitioner was that order dated
8 August 22.
8th August 23, passed by law and a single judge in the writ petition was not complied with, in which order direction was given to the respondent to the representation. Consider the common representation dated 8/1/21, which was submitted to the authorities by the petitioner. Today, when the contempt petition comes up for consideration, memo of compliance dated 15/4/24 is filed by the learned of the respondent, in which it is inter alia stated that the representations given by the complainant has been attended to and the same is decided. Copy of the order of legal endorsement dated 12/9/23 is produced on record. For any of the above, the directions of learned single judge can be said to be complied with. Paragraph. If the complainant has any grievance about the endorsement of the order passed, it is open for the complainant to institute independent proceedings under appropriate nomenclature to be considered by the court of the appropriate forum in accordance with the present contempt proceedings at this court. Does not survive it. In view of the compliance as well. Please.
December 32, Shrimati Vijay Nayak. Lords, I appear for the accused, praying for a week's time to file an affidavit. We are filing NOC Vakalat as well. Week's time may be given. I'm taking instructions.
But you had taken time on 15/4/2020,
My lord, that's
the 28/3/2024.
No, my lords.
You are not taken.
I have not taken, my lords. I'm coming for the first time. my lord. A week's time may be given, my lords. By next Monday, I'll be filing.
Consideration of representation.
I'll file my affidavit.
No, you have to tell whether consideration has taken place or not. You can't go on spending time on all these matters to ensure compliances. Compliance should be automatic.
I will take my instructions and make respectful submission.
Last time we recollected you had taken.
We
Maybe
remember
the
that's what-
impression, you may be right.
Yes.
All that. After vacation.
Much.
29th of June, 29th of May.
Grateful. December 33, Mr. Manmohan PN.
Matter I pray for some time, Lord, because of the election work, Lord, I
For-
could not contact.
For June.
Please, may I make one request, Lords? Adjacent property, my lords, there is one more contempt pending.
You will file objections.
How, that may be clubbed along with this.
Which one?
Is contempt number 600 and 49 of 2023.
649
Yes,
of
23.
So we'll say to be listed with contempt petition number 649 of 20.
Obliged.
Urgent, seal number 35. The NS Bhatt.
Not complied.
Compliance is done.
Not complied with.
Non-compliant.
In spite of a observation, last your lordship, kindly see the last observation made by this honorable court. Their counter is rejected.
One of the court managers.
Please.
Yes. Filing additional affidavit.
Of compliance.
It is not according to us, not the case. Because if 10% is granted not every year, it is more than the regular employees. Now there is a proposal.
Okay.
By the.
But the
Honorable-
order, you should have taken up that challenge, you should have challenged that order, no?
Not even in the learned single judge's order, it is not there.
He had made the regular thing clear in the order.
And your lordship, kindly see your lordship from 1/4/2007, even enhanced salary in law, arrears still. In spite of your lordship direction.
Paragraph 3, we have said that.
Please.
Is at a time, not every year. Is every year, not one time measure.
Now, my lord, may I take your lordship to additional affidavit, paragraph 6, my lord.
But why you do not tell the learned judge, saying if you make this order, it will exceed the regular pay scale itself. Having not said that, you come and plead the grounds which you should have taken before the adjudicating judge himself. You come here and say, we are unable to comply.
Now we are filing appeal also, my lord.
At least that you should do. Otherwise, as long as the order stands,
It is
we have
ready,
no
my lord.
discretion
Today
to
it will be
disobey our own
filed.
order.
We are filing an appeal, my lord, against the employees. The last may kindly have it after vacation. That's by the time.
May I say bit, my lord?
No, otherwise you will get more than what the regular employees.
Even court.
10% every
Even-
year,
even court-
unheard of.
Even court managers, your lordship, in other state, they are more than 1 lakh, 1.5 lakh per day.
Question is not that. In service law, it is always well settled. For employees of your kind cannot transcend the status and emoluments of employees of the regular kind. It's the first principle which Justice Ramajoy says in a separate chapter, services under the state. It's a treated subject.
But my only submission is that right from the beginning,
Learned government advocate, Ms. Mahindra wants to file further affidavit.
I have already filed affidavit, additional affidavit.
Learned government advocate, Mr. Mahindra stated that the authorities have filed appeal in the order, in which one of the ground is to counter the observations made in paragraph 3 of order dated 6/3/24. In that view, without insisting upon the observations, said observations made earlier, from a time is granted to the authorities to pursue the appeal. To be listed on 24th of June. By that time, you get some order in the.
Please, that's what.
36 urgent, seal number 37. Satish K.
The last may kindly have it after vacation, not by the time.
Grant of increments,
Grant of increment
application.
after vacation.
You will take notice also.
I'll take notice.
Notice 25th of June. Learned Government Advocate notice on behalf of number 2.
Number 38, Bharat Kumar V.
Lord, may I
The
request
complaint
for
was-
some more time, Lord, because of these elections, Lord, all officers are deputed, Lord, and personal.
Election duty is assigned to your people.
Yes,
Assigned.
yes, they are on the strong room in charges.
They have taken.
Yes,
I've been told that it is almost ready, a week.
yes.
Immediately after vacation, we can.
Please.
By that time, elections also.
10th
of June.
Publish.
Please.
Number 39, Ravindra G. Gayatri.
Permitted to file an affidavit. In this case, we have published the provisional seniority list, my lord. 4/4. And 18th is the last day to
Copies.
What was the order?
Consider my case for my consideration of representation for my lord promotion to the post of professor.
Was it time bound?
3 months time is there now. Page 28. Consider the case of the petition of promotion if he is so eligible. Page 28, my lord.
within 3 months.
3 months.
4/4, we have published the provisional seniority list, my lord.
No, we are asking, have you complied with the order? We are not concerned with provisional seniority list, second provisional. We are asking 3 months. See the wording of the learned judge. Within 3 months from the date of his, at any rate, within 3 months, we have to attribute some meaning to these English words.
I explained in this affidavit, my lord, why I mean permitted to file this.
And I'll go through it. Just now I received the copy. And that
Final seniority list is done. Provisional seniority.
Provisional
list is-
seniority list ಹಾಕಿದೀವಿ sir.
Correct.
Up to 18th is the last date. 18/4 is the last date to file objections.
To that.
Yes, my lord.
After finalizing the list, you will go for the
Not,
DPC.
yes, my lord. Not by the accused number 1, my lord. There is a committee, my lord, for that purpose. You will send that to the principal secretary medical education, my lord. And third respondent is the necessary party, my lord. My friend has not arrived. Third respondent, CAO, is the member secretary of the committee to this contempt petition. The third respondent, governing council represented by CAO, my lord. Page number 20, my lord.
It's a time bound way. Where time is given, it is given to accomplish all supportive acts. That is the object. Otherwise, you should have sought for extension of the time.
I
Where
may,
time is prescribed by the learned judge, we have to honor it.
page number 7, my lord. For a moment.
Of your objection.
Yes, my lord. Affidavit, my lord.
Paragraph 7.
No, my lord.
Page 7.
Page 7, my lord.
But I will go through it, my lord. Just now he served the copy.
Where are the English translations? You want to make single judge court?
Give
Oh, give translation at least.
I do.
Learned counsel for the respondent shall supply the translation of the orders annexed with the statement of objections before the next extend over to 3rd June,
Date may be given.
8 June.
Please, much of.
Tenth June.
10th June.
Sir, number 40, Abhinav Ramanand.
I'm appearing for the petitioner. Not this, despite there being an order to imitate my name in the RTC. And there was a time for completion, my lord, that was directed, which was 3 months, which my lords will kindly get at page number 18. And the-
Entering name in column 9. Mandate. It's a mandate.
Yes.
not consideration.
Not
You
a,
have to enter.
Your Lordship may kindly have it after vacation.
Next date, you have to report compliance. Otherwise, time will be spent in this one.
November 20.
My lord, 28th.
Why they do not do, I understand what we want to say from this side.
Their version is that, my lord,
Order under the order of learned single judge brought under the contempt jurisdiction.
in fact, they have issued an endorsement stating that,
Contemplates a
my lord,
mandate against the
match,
respondent to
which
enter
I am
the
not
name of the
producing.
petitioner in column 9 of the RTC within 3 months. Full stop. The order passed was on, the order was passed on 28th of November 22. Despite passage of long time, paragraph. Compliance is awaited, paragraph. Government advocate assures that before the next date, the order will comply unless the order contrary are obtained by the appellate court.
Failing which, my lord,
From the appellate court.
failing which, my lord, the presence of the Tahsildar.
Direct presence of the person. Does not do this.
Unless the order is complied with, the who implement with this
Tahsildar.
Tahsildar concerned shall remain present personally before the court on the next date, 10th or to 10th of June. So sufficient time to comply.
Number 41. Is Pita Arvi?
In this matter, I filed my wakalat today, Millards. We are ready to take the corrective steps, Millards. However, I'm facing a slight practical difficulty here, Millards. I have forwarded the entire case file with the letter telling communicating that the order has to be complied to the Deputy Commissioner, Millards. He is posted on election duty. May I request for a short accommodation in this matter, Millards?
Election came only now.
Correct.
Order was made on 24th March 2023.
Please, Millards. Millards, may I make one humble submission here, Millards? Millards, it came to my knowledge only on 27/10, Millards. In fact, if I may submit, Millards, in their own petition, they've told that, Millards, there was a transition that happened from Dottaguru Gram Panchayat to the town Panchayat, Millards. There was an administrative disarray where entire institution from Gram Panchayat to town Panchayat, it was upgraded, Millards. I took over charge and the entire documentation, assets and accounts were handed over to me only on 3/8/2023, Millards.
Even then, how many months? 3/8.
Millards,
3, 9, 10, 11, 12, 1, 2, 3, 4. How many months?
I humbly
But
bow
we
down,
are
Millards.
not here to listen to the stories. We want compliance.
Please, Millards, I humbly bow down to what my lords is telling, Millards. Humble request is kindly grant 2-3 weeks time, Millards. Once the election due, Deputy Commissioner assume.
Number 1, you are number 1.
Please, Millards.
Gram Panchayat.
Please, Millards.
Learned advocate, Miss, what is your name? Good name?
Deepika Joshi.
Deepika Joshi.
Now
was
it is upgraded as town
clearly
Panchayat.
stated in order, in an attempt to defend the non-compliance, that since the elections are imminent, the officers are engaged in the election duty. When it was pointed out that the order was passed as back as in March 2023, she stated that the order was served in October 24, October 23 only. Full stop. Neither of the submission convinces the court. However, in order to give opportunity to the respondent proposed contempt, some time is granted to comply with the order, which shall be done before the next date.
Please,
Put up on 29th of May.
Grateful, Millards.
You comply with on.
Please, Millards.
Number 42. Virupaksha PA.
The direction of the Honorable Single Judge Manoj, at page 37, Manoj. Consider the claim of the petitioners, Manoj.
What is it?
May kindly have it after vacation. There's a direction to consider the case of the petitioner for issuance of Hakkupatra by the DC.
Direction was
Front
issued
of
to
dwelling houses.
direction was issued to Deputy Commissioner.
Consider the.
These are all poor people. How many times poor people should come here? We do not understand the logic with which the government and officers work. ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಅವರು ಎಲ್ಲ ಬಡವರೆಲ್ಲ ಇಲ್ಲೇ ಬಂದು ನಿಂತ್ಕೋಬೇಕನೋ ದುಡ್ಡು ಕೊಡೋರು ಯಾರು ಅವರಿಗೆ how we should do these things? Why we are spending so much time for you should report compliance of the orders.
We have called all the departments in the CO mode.
In fact, in one matter, my lord has structured that you are also party to that now. All department secretaries. This should somewhere it should come to an end. The people don't have so much time to come here, stand here, and waste their life here unnecessarily.
We want a definite mechanism to comply. So that your burden is over, this filing is less, tendency is less. Unnecessary contempt comes after 1 year.
They have taken people for granted. If it were to be in France or some other country, revolution would have happened. Our people are very, very mild. They are showing mercy to your officers. Please tell them our observations.
30th.
Ready notice matters, serial number 43, Chandra Tariga case.
For the petitioner, my lords, and he's seeking a passover, my lords. Passover, my lords. Senior is on his legs, my lords, in another court.
Senior on his legs. What is it about? It's petition.
After vacation, we'll have this matter.
No, there's some urgency, my lords. The mining operations are come to a shutdown.
But 2022 matter. What's the urgency?
Lords, it may be
It's an
Passover, my
list.
lords.
4th of June.
Wait for-
44 urgent, serial number 45. Vikram Mani Rajagopal.
Last time, your lordship had said to go before some other bench, my lord.
Don't entertain the doubt whether being arising out of surface, your lordship should hear or some other bench. I am in your lordship's hand, lord.
Senior counsel is appearing here.
Yes, he did not.
Date,
The matter arises, lord.
Honorable Justice Nagaratna's judgment says what? There is judgment of Justice Nagaratna, madam, on Surface Act only, which delineates the jurisdiction of the writ courts in interference.
No, my lord,
There is such a judgment.
It's here, my lord.
fine, my lord. Last time,
In fact, there is a later judgment. This is the first judgment, my lord, in the compilation. Lord, on OTS availability, my lord. The lordships have said that.
My lord, if I
Page 11, para 14.
Of the judgment.
In this compilation which I gave you, no? At page 10, para 12 begins. Even otherwise, as observed herein above, no borrower can, as a matter of right, pray for grant of benefit of one-time settlement. In a given case, it may happen that a person would borrow huge amount, for example, 100 crores. After availing the loan, he may deliberately not pay any amount towards installment, though able to make payment. He would wait for OTS scheme, then pray for grant of benefit under OTS, under which always a lesser amount than the amount due payable under the loan account will have to be paid. This despite there being all possibility for recovery the entire loan account, which can be realized by selling the mortgage security property. If it is held that the borrower can still, as a matter of right, pray for the benefit under OTS scheme, in that case, it would be giving a premium to a dishonest borrower who, despite the fact is able to make payment and the fact that bank is able to recover the entire loan account, even by selling the mortgage security properties, either from the borrower or the guarantor. Lord, in this case, what happened, Lord, was an OTS scheme was given. Time was extended. They did not pay within time. So it was cancelled on the ground that you didn't comply. The learned judge, my lord, while noticing the correspondence, he notices a later letter and says there's no reason given. The earlier letter is also part of the record. And says that he made the payment, my lord, partially.
Para 14.
Hello, what had happened last time? They said it will not, the matter will be heard in some other bench, my lord. Kindly pass over, or tomorrow is 1 day's account. I'm ready.
In fact, your lordship
Senior is
sitting
appearing,
as
my
the
lord.
learned single
In this
judge has
matter-
taken a somewhat similar view, my lord, in one judgment which I have given, my lord, in this judge serial number 4.
My lord, what is?
Nitesh residence.
Nitesh Estate.
Yes.
Is it, was it before the DB?
I think they filed an appeal but withdrew it. That also order I have produced, my lord, at page 58. Your lordship's operative portion, my lord, is at page 55. Page 54, bottom, my lord, extract from Manne Guru Prasad judgment.
My lord, my lord, day's account tomorrow, my lord. Senior is appearing, my lord. And my lord, I will produce my accounts, my lord, wherein I have paid the complete OTS amount within time, my lord. And it was produced before the learned single judge, my lord. For some reason, it's not produced yet.
Within time, entire payment is made.
Yes, ma'am, with interest.
You are for bank. That's not correct.
No, man, I have.
Actually not correct.
I have
Figures
filed-
are before your lordship. I have the figures with me, my lord.
I have, my lord.
The OTS amount, my lord, offered was 17.5 crores. And then, my lord, that was in the initial stage. That was in the year 1919. My lord, in 2020, they asked for an extension. And as per that extension, they have paid first 3 crores, then 15 crores, and then after the OTS was cancelled, they made 2 payments. But by then, my lord, the amount due has gone up to 22 crores. Interest, my lord, in the original OTS offer itself, it said, if you pay within this.
Accept that.
Accepted part. Yeah, that is accepted. My lord, what we are saying is, OTS offer said you pay X amount plus interest till the date of payment. Now, he did not pay the full amount. He paid part of the amount. And then, my lord, we contended that since you are not complied with the OTS in full, if your lordships would see, my lord, my letter withdrawing the OTS at page 187. Page 187.
Whether Justice Nagaratna's judgment is diluted by the subsequent judgment?
No, my lord. My respectful submission is no. That in OTS matters, writ jurisdiction.
So if they are not for X, Y, Z reason acceptable for want of payment of full amount, we can't force them to say that you accept the OTF.
Well, there's a Supreme Court judgment, my lord, that says otherwise.
This is also apex court judgment only.
My lord, OTS, my lord.
Which,
My lord, Madhya Pradesh High Court, my lord. Division bench, my lord, passes an order that has been confirmed by the Honorable.
which year?
My lord, 20.
So we
22,
understand
my
that,
lord. 22, my lord.
Mr. Counsel,
This is 23.
you have become senior now.
No, I will not, my lord. That's, I was saying something. I thought.
We'll not
Very
take
well,
your
very
hands
well.
for
No, no.
Once you start arguing.
Ah,
we'll-
yes, sir. Very well.
Where is which judgment? That 2 page. Their lordships have only said question left open, not interfered under 136, not an affirmation.
And that is 13/5/2022.
Yes, my lord.
But the judgment of Honorable
Yes,
Justice
ma'am.
Nagaratna Madam is 23.
I will. A short account. The division bench order covers everything. Almost similar circumstances.
There are 2 judgments in my compilation, Lord. The first one, Honorable Justice M.R. Shah and Honorable Justice Nagaratna. The next judgment is at page 12. Honorable Justice M.R. Shah and Honorable Justice Krishna Murari. They follow that and emphasize it, my lord, at page 19. Para 22. They refer to the earlier judgment.
So they invoke a novatio.
By a court order, can a contract between the parties be interfered with and a mandamus issued under 226 was the question. But if they had paid the entire amount due, along with the interest which was stipulated in the OTS itself.
That amounts to rewriting the contract.
Please. And my lord, your lordship knows this OTS, my lord, is mainly for somebody who is not in a position to pay. Their extenuating circumstances are there. So the bank says, I'll reduce something, you pay and be done with it. Not in a case where a person has assets. Even the RBI directives say that if the person seeking OTS, there are sufficient means to pay if has assets, then OTS is not the remedy.
Short.
You can't offer OTS against OTS.
My lord, senior is appearing.
Your own OTS you are offering.
Allah, I will.
Interim order is there.
Interim order.
Yes, there's an order not to precipitate, but we are not able to sell the property.
Day after.
Yeah, very well.
Day after.
18th. 18th.
18 dollars. Report passed by the court. The office notice put up. Full stop. Accordingly, the writ appeal has been posted before this bench. Paragraph. Learned counsel for the respondent seeks time. Stand over to 18th of April. Interim leave is there.
Yes, it is there.
Interim order shall stand extended till the next day.
Number 46.
Appellant.
Mr. Shamanna BH.
My lord, there is a delay of 59 days in filing this appeal, my lord. The order passed in writ petition on 14/8/2023, my lord. The appellant society held a board meeting on 21st September 2023. And there is some delay. In that part, my lord, some documents are required to be filed in translated version. Hence, it took some time, my lord. And there is a delay.
Yes, what is this matter?
My lord, the appellant society has called for the post of CEO. And in this regard, my lord, the appellant society has requested the second respondent to conduct a written examination. The second respondent has prepared question papers of only one set. Thereafter, the appellant society has requested them to prepare 3 sets of question papers to avoid malpractices and all, my lord. So accordingly, they prepared 3 sets of question papers. By interchanging the questions are prepared in the first set of question paper, my lord. But they have not interchanged the key answer respectively. After examination, some candidates, they sought for OMR sheets and they found that the irregularities done by the second respondent. In this regard, the letter correspondence made to the second respondent.
Why a fresh examination?
Because there is some irregularities.
What is the irregularity? They have done it deliberately, different questions papers, so that each one of them will not copy the other.
Yes, as per our request of the appellant society, they prepared 3 sets of question paper.
Correct.
But what they did, they interchange the questions, but not interchange the key answer to this, those questions, my lord.
Which we corrected, my lords, and announced the results and gave them the key answers and answer
They
papers.
gave
and everything.
the key answers and then they pronounced the result.
Pronounced
What is wrong with it? Very sensible order it is.
There is nothing.
Number 47, Sumoto Expedition PA.
This is a petition initiated by this honorable court, my lords. Unfortunate incident where the boy and girl eloped, my lords. The girl's parents tracked the boy's mother and tie her to a rope naked, my lords. And action was pursuant to this court taking sumoto cognizance, my lords. All the 12 accused were arrested. Charge sheet has been filed.
Belgaum district.
Belgaum district, absolutely, my lords.
Land is also granted, no?
Land is given, changed land also is given.
They
Mutation also has
sought
been.
for change.
Absolutely.
Nothing survives for
Nothing
consideration.
survives. Only can I request, my lords, in special circumstances, your lordship, in view of the accused, the trial may be concluded, keeping the peculiar nature of the matter, my lords, so that the justice is what, my lords, not only.
Charge sheet is filed.
Charge sheet is filed. I'm producing the charge sheet also, my lords.
Something will be required for future monitoring.
Yes. Court officer, you know.
Future provision.
Show me the
Amount
judgment.
is given.
Amount is also given.
Yes, 5 lakhs amount, 2 acres of land and.
2 acres.
They monitor the health,
land.
2 acres of land. And our health is also, my lord, being monitored and. Delhi High Court, is it? Delhi High Court, Supreme Court. In fact, it's in the interest of the accused as well as the victim, my lords, and the speedy justice, my lords, that probably this will be one of the rarest of rare cases, my lords, because the matter was initiated by your lordships, my lords, where charge sheet is filed, investigation is done.
Compensation is also given.
Yes,
5 lakhs. So that is, everything is available.
Everything, we have filed status report, everything is on record.
Will pass.
Grateful.
Thank you.
No,
for
your,
doing
it's
so
your
much.
lordship's instance, my lords. In fact, one is the land and 5 lakhs. The mental health also, my lords, in fact, my lords were, former Chief Justice, my lords were pleased to speak to the doctors, find out the mental conditions, include, in fact, stop the press or, various politicians.
He was minor, no.
No. Mother of the boy, my lords. District health officer, district health officer.
District health.
Why, women and child welfare officer is there, no? Separate post is there.
Welfare
They can
officer.
also do.
Women and welfare, child welfare officer. There is such a cadre.
There is, ma'am. Your lordship,
There is.
right. There is, your lordship, right.
So every 2 months or 3 months? Every 2 months he will go for
Once in 2
1
months.
year.
For next 1 year, my lord.
For 1 year.
Or your lordship may ask us to file the report.
May not be.
May not be.
We will not monitor all those.
Please, please.
No. He may file report to the superintendent of district, police
Please.
superintendent,
Please.
ESP, whatever the designation is.
And especially outer limit of 1 year if you can, lordships, or 6 months, the trial also, my lords.
That is also.
That, so that,
He say expediency.
or some, because the reason is, my lords, especially offense against women and the nature of offense, my lords, otherwise we would not.
Very, very
That will-
obnoxious.
And one more thing, the message will go, my lords. That's a important, my lord. The message will go throughout that, after the trial, expeditious trial, and whatever follows, my lord, has been done speedily, so that it should not happen again. That's the whole idea, my lord.
In what way? Message to.
That, my lord, perpetrators will not be spared, my lords.
That will.
That way, because I mean,
That is before the memory fades.
before a memory.
Order itself will be a message.
Yeah,
Yes.
that is what, that's the.
That is.
Because otherwise, my lord, the offense, they think 10 years, 20 years will.
That's what.
Grateful.
48 urgent, seal number 49.
Not here for the,
AJ James, 14%.
here for the respondent university, it's my lord.
AJ James, 14%.
What is 48 group?
48 is a CBG. ಬೇರೆ matters
Evaluation. After
December 50. Sri Mukanappa.
Feedback, then in the second half we'll pass. This may be kept. Recall in the after recess.
December 49 Passover. December 50.
50, Your Worship, I am representing Respondents Council, Your Worship. Seeks a short accommodation, Your Worship, because it's not wild work.
After vacation.
Please, Your Worship.
19th June.
'51. Agents number 52. Narendra Kumar.
Nobody. Before?
Number 52. Narendra Kumar.
My lord, still not complied with, my lord. I have received the action taken report, my lord. It's almost the same thing what was there 2 years back, my lord. Lord, there are 1 lakh people waiting for their refund, my lord. There are 1 lakh depositors waiting for refund last 5 years. They have submitted claim. They don't even know what happened, my lord. Requesting my lordships to direct them to at least inform those people whose claims have been cleared, whether they're accepted or not, my lord.
So you wanted to file fresh report?
My lords, I have filed, my lords, an affidavit along with the respective reports, my lord, of each of the competent authorities. My lords, I have made a table, my lords. It has been filed on 6th of April, my lords.
I've gone through it, my lord. It is not still complied, my lord. The order is not yet complied, my lord.
If my lords permit me to submit, my lord. My lord, we are before the Honorable Special Court, my lord. There is a procedure given in the statute, my lords, and we have to follow the statute, my lord. The 52 petitions are filed, 7 petitions are filed. Lord, and those matters where, my lords, the Honorable Special Court has been pleased, my lords, to pass an absolute order. They have been stayed, my lords, by this Honorable Court with a single judge, and my lord, some matters in the appeal stages, my lord. We are moving those matters also, my lord. But my lord, all that is possible, my lords, has indeed been done, my lords, by the competent authorities.
My lord, verification has got nothing to do with those procedures, my lord.
How long that ultimately,
my lords,
it is the statute intends to protect interest of the investors.
Please, my lord.
Before investors wither away in thin air, something should happen.
My lord.
When it will happen?
The point is well taken, my lord. But there are several matters, my lords, which are pending before the Honorable Special Court, my lord. The Honorable Special Court is passing the orders. My lords, once the Special Court passes, my lords, an order under 5.2 and makes the interim attachment absolute, Lord, several first appeals are pending before this Honorable Court, my lord. And this Honorable Court, my lords, has stayed the matters. We have moved the matter, my lord. They will be heard, my lords. So once, my lords, the stay is lifted by this Honorable Court, my lord, will be able to proceed for the attachment of the my lord, auction of the properties and realizing of the money, my lords.
All proceedings are stayed.
My lord,
we have given.
Sorry. Sit down. My lord, not all proceedings.
Sit down. We'll hear you. You are interrupting learned counsel. Yes.
Plus, we have given.
How many matters are pending? How many matters are stayed? Give the list.
My lords, I have given a list, my lords, of each of the financial establishment, my lords. I have given.
No, wherever there is no stay.
Please, my lord.
What has happened to those
Plus,
matters? What is your role there?
Plus, wherever, once the interim attachment has been made absolute, my lords, by the Honorable Special Court, and in all such matters, my lord, where there is no stay operating in before this Honorable Court, plus we have called for auctions, my lord, and we have indeed realized the money. And in some of the matters, my lord, even money has also been, my lord, released and disbursed to, my lords, the investors proportionately, my lord.
Where are the data? Where is the data? Not submission. Give us, how many people you have given back the money?
For example.
When it was given? To how
First,
many
kindly
people it
take-
is yet to be given?
My
Why
lords.
not given?
My lords, may kindly take page number 27, my lords. One such, my lords, financial establishment, IMA, my lords. So I have given my lords as my lords would kindly see, page number 27, my lords.
Of your,
Of my affidavit filed, my lords, on 6th of April 2024, my lords.
you appear for whom? Mr. Budia?
Lords, I appeal for the competent authority, my lords. So,
Competent
Special
authority.
officer and the competent authority under the provisions of KPID Act, my lords. 27, if my lords may kindly take, my lords. Lords, that's the FE, my lords. The financial establishment, my lords, is Mrs. IMA and its group entities, my lord.
These are all poor people who have made investment of their hard-earned money.
My lords, making a very responsible statement, my lords. We are leaving no stone unturned, my lords. We are moving all the matters before the honorable court and also before the single judge, my lord. And wherever there is no interim order, my lord, indeed steps have been taken, my lords, to attach the property, auction it, and then disperse it. My lords, the pointed question of your lordships, my lord. My lords, may kindly take page number 29, my lords. Of my affidavit, my lords, filed on 6th of April in compliance of your lordship's directions, my lord. My lords, I have given, my lords, the up-to-date, my lords, action taken in each of the financial establishments. Which has been filed, my lords, on 6th of April 2024, please, my lord.
Free. After vacation, we also go through.
My lord, just one submission, my lord. My lord, there are 20 companies, 1 lakh people, they have given money only to one company.
Processed or not?
My lord.
My lord.
Partly processed.
Partly processed.
My lords, partly processed, my lord. My lord, in fact, my lords, I should confess before this honorable court, my lord, in the initial years, my lord, there was no much progress because the act were new, the officers were new. But my lords, once your lordships have issued directions to us, the honorable special court, my lords, is passing orders in a time-bound manner. We are filing, my lords, the 5 petitions. And wherever there is no stay, my lords, we have indeed taken action and auctioned the property.
We wanted to know the total number of claimants.
It is different, my lords.
Which have been, yes.
My lord.
And what happened to the claims?
Please.
Wherever they are stayed, we can understand.
My lords.
Wherever there is no stay,
please, my lord,
there should be further process of the matter.
Money
Money should reach the investors.
My lords,
All poor people.
My lords, may kindly permit me to read, my lords. My lords are not able to lay their hands on the paper. My lords, may kindly permit me to read, my lords, what I mentioned before this honorable court. But this is, my lords, the IMA, one of the financial establishments, the biggest scam that has rocked the state, my lord. And my lords, the action that we have taken, my lords, each financial establishment, my lords, we have produced before this honorable court. And in IMA matters, my lords, I say, it is submitted that another set of properties which are made absolute to the special court were auctioned, and the sum of rupees 66.66 crores was realized. And further, it was distributed to 53,142 eligible claimants as per the equitable distribution principle. Secondly, my lord, it is further submitted that the payment to 50,797 accounts are successful for rupees 63 crores 84 lakhs 28,000, and payment to 2345 accounts have failed for rupees 2 crore 82 lakhs. So
when the timeline we want, when that money was paid to each of them, all poor persons, especially IMA, all poor Muslims have invested money, and they do not have money at all. Therefore, we made, because one of the orders is made by me.
Please, my lord. Please, my lord.
What has happened to poor people? ಅದೆಲ್ಲ ಬಡವ್ರ ದುಡ್ಡು ಅದು ತಗೊಂಡು ಮುನಿಸ್ಬಿಟ್ರೆ what should happen to poor people?
Point one, we have indeed been following the orders. Whatever money has, my lords, been recovered.
Give full particulars.
Please.
How many properties were attached?
Please.
How many properties were auctioned? What was the time taken?
Please.
What is the auction proceed? What are the auction proceeds?
Please.
How this money is distributed to, even on rateable distribution, whichever principle.
Distribution,
how you have done that?
Please.
When the last of the payment has been made,
please.
Subsequently, what happened? Maybe that was more than a year back. The recent past.
But this is updated, my lords, as on the date of filing, my lords.
The latest payment was made on which date?
That dates I'll mention, my lords. I'll prepare a table in addition to the affidavit, my lord. I'll mention a table.
Otherwise, nobody will believe us tomorrow. These are all poor people, very poor people. Therefore, you have to make everything give full statistical data. When, what happened, why not happened?
Please,
these things we want.
Please. My lords, may kindly, my lords, permit me to say this, my lord. Indeed, my lord, some of them are poor, but most of them, my lord, have said that they've made deposits in cash in excess of 10 lakhs, 15 lakhs, my lord.
Anyway, they may be rich.
Please, please, please.
It is their investment.
Please, please, please.
It is their property
Please,
that has to come back to them.
Please, Lord. Please,
That we need to, that not only poverty, there are, poor section is one thing. He may be a billionaire, he has invested money.
Please.
That has to go back to him.
Please, Lord, please. But indeed, my lord, I can assure this honorable court, my lord, that sincere efforts are being made. No stones are left unturned, my lords.
You give full
steps-
data, not like. this.
Indeed,
But
indeed.
The
my lords.
argument, nothing will be believed by us.
Please, please, I
Give
bow
full
down.
data,
I
how
bow
it has
down.
been done,
I bow
when
down.
it has been done, how much money is, produced, generated by auctioning of the property.
Please.
Which property have not been auctioned, which have been auctioned, how much money has come, why auction has not taken place.
Please,
Everything, so that we can fix the responsibility
please, my lord.
and nail the concerned person. Otherwise, it will go on like thing. It's a not Panchavarshika Yojana. Somewhere it should come to an end.
Please.
Give full particulars on the next date of hearing.
Please.
My lord, can I submit something? My lord, there are 300 cases totally made absolute. They have hardly made absolute around 7-8 cases.
Let him give the full particulars. It becomes easy for you,
My lord.
for us
My lord,
also.
Just this, whatever he's talking about, only one company, remaining 18 companies, no money has been given.
All. Which
Only
remain?
one. IMA is a
Only
respond number
IMA they have
15.
done.
Yes, my lord.
Others you have
Remaining-
not done.
So,
No,
mind you, I have done a list.
not-
my lord.
not-
I'll make a tabular list, my lords. Now the petitioner wants, my lord, that the statutory authority acts as per his convenience. He tells us that you cannot dictate, you cannot, my lords, distribute money in equitable terms. Lords, we have gone before the
That's
honorable
all right.
special
Whatever
court.
you have done, you show that. He cannot
Please.
dictate terms is one thing.
Please.
But he is airing the grievance on behalf of the voiceless people.
Yes.
That you
That,
cannot
my
deny.
lord,
We
that
have
is
seen
pending.
that. Maybe the last time you said some allegations, etc. Leave it apart.
Please, my lord, please, my lord.
What has happened on the road, you show that to us.
Please, please, my lord, please.
My lord,
But may I make one
just,
submission?
just
What?
one request.
We'll file better compliance than the direction. What?
That's why.
My
It's a
lord, let them-
BIL now.
let
We
them
need not
inform-
hear you much on that.
Sir, no.
It's,
Let them
our
inform,
child now.
let them inform the people whose claims have been accepted. At
On
least
next.
they live happily, my lord.
Reserve for the next.
My lord, serial number 52.4.
Yes.
My lord, it is just a notice that is issued by the special officer. My lord, calling upon the petitioner to pay the arrears of rents, my lord, in which she is residing. My lord, one more property which is attached can be available for sale if this writ petition is dealing.
In this
And-
matter.
Yes,
Please,
my
my
lord,
lord. In fact, my lord, it become infractious,
52.4.
my lord. In fact, my lord, 9,
So have you auctioned the property?
illa, because my lords, 9455, my lords. My lords, the writ petition was filed before this honorable court, my lord.
Yes.
My lords, the petition before your lordships, my lord, claims that she is the tenant of the property by virtue of an unregistered lease deed for a period of 3 years. But even that, my lords, has come to an end. So she had come before this honorable court, my lord. This petition has become infructuous in as much as, my lord, we have already taken, my lords, the possession with the help of the
Of
revenue
that
and
property.
of that property, my
To
lords.
auction also.
Once the petition is disposed of, my lords, we will put the property, my lords, because now the petitioner advocate, my lords, also was not here on the earlier occasion.
In 3 years has also expired. Process it so that the petitioner itself proceeds.
I have not, we have got the position of the property, my lord. The
You have got the
petition-
position of the
How, with the
property.
help of the police and the revenue authorities, my lord, we have taken over the position, please.
And when are you going to auction it?
So, my lord, I can make a submission, my lord, no sooner the petition is disposed of, my lord, at the earliest within.
Where is
next-
the interdiction for auctioning of the property?
Because the petition is pending before this.
No,
honorable-
that is to do that. Petition is for that purpose.
Please, we'll take action, please. We'll take action.
This we are segregating.
My lord, yes.
Dispose of this.
Disposed of.
We are- we are
They
segregating.
sell
you-
that property in a
Yes,
time-bound way.
they are seeking
And
only for
distribute.
quashing of that notice, my lord.
Your schedule of auction.
Yes. Give
Schedule of auction, give on 22nd.
My lord,
on 22nd, give schedule of action, what all you are going to do.
Auction.
please,
Auction date also you fix.
please, my lord, please, my lord.
So this 52.4 to be segregated, to be listed on, write down, to be listed on 22nd of April. On that day, learned counsel, Mr. Viresh
Please,
Udiya
my lord, please, my lord.
will make available to the court the schedule for auctioning the property.
Please.
Obliged, my lord.
My lord,
Yes, please.
my lord, just one request, my lord. The people whose claims have been accepted, if they are informed, it'll be easy for them, my lord. There are 1 lakh people, my lord.
So that will do afterwards. This is to single out the matter. We can-
My lord, another 52.1, my lord. There are 3 containers, 2 of them are not appearing, my lord.
Next day.
And another case, my lord, 514 of 2021, my lord.
Let us see.
There
Let-
is
let
no
him give-
status report given last 2-3 years, my lord. At least that may be ordered, my lord.
One by
Directed
one, we'll go, wait. One by one, we'll go, so that it becomes easy for us, perhaps easy for you also.
Please,
Accept this 54 point.
please,
52.4.
please.
Third of June.
Would my lords, my lord, take the matter of 23rd, please, my lord. 23rd, my lord. But the difficulty, my lord, some of the officers, my lord, on election duty, my lord, so I may need some time. 23rd, I pray for, my lords. Obliged.
In the weeks accommodated, weeks time, in weeks time, grant my lord, to take steps to.
Any compliance is done?
Present accused will be transferred to.
You have not
another-
taken steps, brother.
My lord, weeks time may be granted. Tomorrow I will take steps, my lord, but because new officer came to that post, my lord, for that reason.
Unsolved. Who are other than state? Others are deleted.
Only a 3 is.
3 to be served.
3 to be solved. Yes, they are deleted. So 3 is private part. Tehsil, that's what. Notice, press notice to the respondent. Returnable on 11th June.
Number 54. The Sanjeev BM.
No complaint. I'm appearing for the complainant in this matter.
In this matter, Marat, to the state government to take a decision on the resolution. Direction to the state government to take a decision on the resolution which has been passed by the MUDA. What has happened in this matter, Marat, the acquisition has been upheld right up to the Supreme Court. The land owners as well as the revenue site owners have lost the litigation. But the MUDA had passed a resolution saying that certain site has to be given to the revenue site holders. The government has to take a decision. Your Lordship may kindly see, as per section 67(2), notice has to be given to the MUDA before taking a decision. Another, we have given the notice 15 days, my lords, gets over on 22nd. Within 1 week, 3-4 days or 2 weeks after that, we'll take a decision after hearing the MUDA, my lords.
Matter went to apex court and apex court, there also they are lost, no? That is the case.
Correct.
When are you going to, that is when it is being done, that resolution of the MUDA is challenged here?
Absolutely.
By the person who lost the case even in the Supreme Court.
Yes, absolutely. Landowners have lost, as well as the purchaser of this sites also have lost.
And the cost was imposed.
Yes,
Cost was imposed by
absolutely.
the Honorable Supreme Court, man.
Lord, so far as the purchasers of the sites are concerned, they are.
Instead of pursuing the review petition, my lord, he comes up with another writ petition. The Honorable Supreme Court says,
Kindly have it tomorrow. See, Learned Senior is there. Today he is not.
No, but we have to take a decision because of the thing, Manoj. Section 67(2) requires to hear the MUDA on the resolution. We have issued 15 days notice is required. 15 days gets over on 22nd. Any reasonable time your Lordship may say, we will take a decision within 1 week or 2 weeks, whatever your Lordship says, we'll take a decision. And we'll.
about 138 members, my lord.
23rd, we are calling it.
Please,
Whatever you have to do,
No,
It's a
no,
very
24th
bad case because the apex court dismissed the
With
challenge
50,000 cost.
with a cost of rupees 50,000. One more you have filed. Perhaps
Yes, but I am not, it's not a
Can't go on.
Instead, not disclosing the Supreme Court, my lord.
court order.
Yes, it's a suppression of material facts with which they
Petition,
approach the
sir,
Supreme
nothing
Court.
has been disclosed as regarding the Supreme Court order.
Yes, yes, we have seen.
Your Lordship, may I have it on 25th. The reason is
25th.
the reason is 15 days gets over on 22nd. We'll hear the mood on 23rd or 24th and take a decision by 25th, my lords. 2-3 days we need to.
Sale deeds have already been executed in favor of the
25th.
members.
Please.
Something should happen.
Please, my lord,
This
yeah.
is too much.
Which interim order?
But in the writ petition, no, there is an interim connected writ petition, it's an interim order.
Interim will be granted in petition 29219 of 22 shall continue to operate till the next.
Till-
Come in the way of government taking. Yes.
No,
Clarification we have.
Please, that will not come in the way.
That will not
That
come in
will
the
not
way.
come in the way, Madam. Your Lordship may record that we'll take a decision and place it before Your Lordship on 25th, Madam.
The state
Lordship may
government shall
record-
take,
take independent.
state government shall take appropriate decision notwithstanding the interim order.
Please, please,
And the decisions will be placed on record.
please.
Great.
One more.
Number 55. Gopal, the respondent, please. Complete the orders passed by this court by depositing another 5 lakh rupees before the trial court.
What was the order to pay?
In this matter, what happened? The respondent filed a suit for declaration and for partition.
You have know that every time you are,
Please,
one time you come,
please.
another time your senior
One
come.
more development
This
has
is the-
taken place wherein the trial court has directed the respondent herein to deposit a sum of rupees 20 lakhs which has been given by the employee to her. And in the petition number 2043 of 22, the learned single judge has directed both the parties to deposit the entire amount in the court, wherein first it should go to the housing loan, where at least property can be saved at the first instance. The writ petition filed by the respondent, please. I filed the status report, I could not get the certificate copies. And 28/3/24, I deposited.
Further amount of rupees 5 lakh to be paid.
Please, in this matter, I request your lordship to. One more orders is passed by the trial court.
We are not concerned with all
Yes.
that. Do you want to comply with your client is here? Ask him whether he wants to be here
I
or ask him.
require 6 weeks time to deposit.
No time will be. All that my
Anyhow,
argument.
anyhow,
Therefore, we do not permit changing lawyers every time separate, different lawyer coming here. Last time your senior came. Before that you had come.
no, no,
Now you have come.
no, I am not.
Yeah, every time you are changing. That is not the procedure.
I'm very sorry, please, in writ petition filed by the respondent in
Ask-
2043,
Ask your client whether he wants to, this
6
is a
weeks
division
time
bench
to-
order.
6 weeks time to deposit another 5 lakh.
We are not going to grant a single day's time. Are you going to pay or not? That is the only straight answer we want. No debate,
We'll arrest
no explanation, no submission, whether you are going to pay the remaining 5 lakhs as directed and committed by you last occasion.
I will.
When
I-
you are
I-
going to pay? Not 6 weeks.
10 lakhs is paid as per the orders of this court.
Up to that only this order
Please.
is made.
5 plus 5, 10 lakhs were deposited by this court
He
as per
should be
the orders of
arrested.
this
He
court.
should be arrested.
Another 5 lakh rupees will be depositing in a span of 15 days.
All this argument was done. You were not here. You can have the video clippings also if you want. You are
Please,
wasting
please,
time
no,
of the, we had
no.
warned that he will be put behind the bars other day. See the proceedings of the other day. They are available on web, on YouTube, they are available. Therefore, don't waste time of the court unnecessarily.
I want 2 weeks time to deposit another 5 lakhs, please. Because he has spent all the money on the,
This was argued that way.
please.
Don't repeat your arguments.
In the meantime, the development, what I wanted to make submission before this court is that
We shall
a
see.
writ petition orders passed by the single judge
Rest of things will fall in line.
in ಇನ್ನೊಂದು ಆರ್ಡರ್ ಆಗಿ ಅವರೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದು ಅದ್ರ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಏನಾಯ್ತು ಅಂದ್ರೆ 25/3 ಏನಾಯ್ತು ಅಂದ್ರೆ ನಾನಿದ್ದೆ
Division
ಎಲ್ಲಾ
bench.
ಅಮೌಂಟ್ ಅನ್ನ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
This is a
ಅವ್ರು
division
20
bench
ಲಕ್ಷ ಮಾಡ್ಬೇಕು ಯಾರು
This is a division bench order. We are wasting
ಪ್ಲೀಸ್
time.
ಇಲ್ಲ ಇಲ್ಲ ಗೊತ್ತಾಯ್ತು ಅಲ್ಲಿ ನಾನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತಾ
ಏನ್
ಇದ್ದೀನಿ.
ಬೇಕಿಲ್ಲ English
ಕಾಪೀಸ್ ರೆಡಿ ಆಗಿಲ್ಲ ಇನ್ನು
make
upload
submission.
ಆಗಿಲ್ಲ.
Please make submission in English because
ಪ್ಲೀಸ್
my lord also should.
one
know
more
what to do.
orders is passed by the learned single judge in a writ petition
My lord,
filed by the
Out
respondent.
of 34 lakh, 10 lakh they have paid. They have to pay 24 lakh 81,350 rupees. Is the balance amount. Let them deposit, my lord.
You want him to go behind the bars or you want payment?
They're left to this court, my lord.
He's a professor,
I will, no, he is a retired person.
retired professor.
Retired person. But you have to pay.
I wanted to bring it to the notice that entire amount should be deposited before the trial court where the amount should go to the bank for the clearance of the housing loan. That was the, on that date, I was not aware about this contempt proceedings. I'm very sorry. In the writ petitions also, that was not mentioned. Sometime breathing time may be granted so that I'll deposit another 5 lakhs because
He should. be
here what
arrested.
happened, the amounts were paid to
Cock
the
and-
accused
cock and
number
bull.
one as well as to his wife by the Dell
Cock and bull
International Limited,
story.
where my wife is not a
Cock and
party.
bull story argument will not listen because all this was argued in your absence. You were not here. Other counsel was.
To come at 2:30 with amount,
Will direct arrest and
with
detention.
amount of 5 lakhs. Otherwise, the orders as directed, as observed in the earlier order will follow. Order of arrest.
At 2:30.
Only a breathing time is required to deposit, please.
Come at 2:30 with him.
2:30, we know what to do.
At least you must show your bona fide.
Please.
Court officer. Court officer. Court officer.
my lord. Serial number 45, my lord. My lord, I had, lordship had adjourned it to 18th, my lord. 18th, senior counsel's father's ceremony, it seems, my lord. So I informed the other side also, my lord. Can it be on Monday, my lord, 22nd, my lord?
What is it about?
OTS.
OTS.
OTS matter.
What is not, yes, ma'am. Monday, my lord, Monday.
Monday 2/3.
Yes. 55.
Small confusion, my lord. In fact, we have completed the latest order of this honorable court, my lord. The memo what has been filed today is with respect to that itself, my lord.
5 lakhs you paid on which date?
It's on 28th, my lord.
You have paid on 28th.
28/3, my lord. In the last date of,
You are third advocate now.
no, my lord. Previous date of hearing also, I was only appearing before this honorable court. Today, my senior was there. No, my lord. No. Senior was also here only. He has just went to attend the phone.
You have deposited that money when?
On 28/3, my lord.
28/3.
On 23/2024, this court has directed me to deposit the amount. On 28/3, it has been deposited, my lord, before the trial court.
You did not, you argued so vociferously without mentioning payment.
I mentioned the payment, just I complied the orders passed by this
All
court
right,
second
all right,
time.
all right. Endless, what kind of advocacy? We'd have arrested him today for your mistake.
No, I filed a memo saying that I complied the orders. Second payment, that was the second payment. Before the second time. That is the memo I furnished before this one. Please. Please.
Entire money has to pay 35,400.
Around 24 lakh balance is there, my lord.
Another 24
Oh,
lakhs.
yes, 24 lakh 81,320.
He is paying now.
In this matter, what happened? The 14 lakhs and odd has been given to the wife of the accused number one. It is directly transferred to the name of the wife of the accused. The entire amount, whatever she received, she spent the entire amount on the medical expenses of her deceased son, the respondent's husband. Now he is aged about 67 years. He was paid around 14 lakhs and odd, out of which he has already deposited a sum of rupees 10 lakhs before the court, as per the orders of this court. Rest of the 5 lakhs he will be depositing before the trial court within a period of 6 weeks.
6 weeks. Why 6 weeks?
He has no augment of income, please.
And then how within 6 months amount?
He has to again beg with the another son.
These things are lawyers' arguments.
So he do not
You
have
had
any
made the
augment of
same
income.
argument. You had made the same argument. Then we threatened you that we will arrest him by order dated 20 March. Then amount has come now. We'll put another threat now. This is how we have to. We cannot
No, I can
do
make
any
a-
other thing
I
except
can-
threatening the people.
I can make a submission.
You have
before
made
this
that.
court what
All,
exactly the
you have made that entire submission. you have made.
he will deposit in court.
2 weeks. Within 2 weeks, he has to pay. What will have been under 25th.
After vacation, please. After vacation. Definitely we'll deposit it. Like within 5th of June, we'll deposit the court.
Is able to manage some part of the.
It's very difficult for him. I had a discussion with him that afternoon.
No difficulty. Orders will make them pay. We know how to get the money.
Definitely. Anyhow,
It's not that he is giving some charity. There is a wife, there is a child. And there is an order.
These are death benefits, what we are. Please.
Living separately.
Yes, yes. She is in one house, where duplex house, and
Divorce has not yet happened.
Divorce has not taken.
No, husband is died. Husband is died.
Divorce
Husband is died.
Divorce has taken place.
Yes.
Yes. Husband is died. All the death benefits have been transferred to in the name of the mother and wife.
His father-in-law.
Yes. He is the father-in-law.
Father-in?
He is the father-in-law. The A1 is the
In absence of the trust. You manage some funds on 25th.
On 25th.
I'll try to.
Not try to,
I'll try
some
to.
amount you should deposit.
Some amount, I'll try to. Let there be any amount not be fixed, please. I'll have a talk to his son also.
Learned Advocate Mr. So and so stated that pursuant to order dated 20th/3/24, rupees 5 lakhs has been deposited with the trial, with the court below. Full stop. The state compliance is placed on placed by way of memo along with the status report obtained from the trial court. Full stop. Learned Advocate sixth time up to 25th of April to further submit that on the next date, before the next date, further amount shall be deposited. Full stop. The time is granted. However, it is observed that the amount which may be deposited within for the next date shall not be less than 2 lakhs. Shall not be less than 2 lakhs.
Please.
Sir, first over matter, seal number 1, the Prajwal Vishwanath.
Withdraw. Okay. No case is made out to make any correction in the order. Accordingly, the not for spoken 2 minutes is spoke. What is it? What is called? Being spoken, not for being spoken is dismissed.
Seal number 49. The AJ James, party in person.
Party in person was absent in the first half when the, what is this, appeal was called out. He was again absent in the second session. To stop in the larger interest of justice, I will stand over to 24th June. Full stop. The registry shall intimate the party in person about the posting of the appeal on the, about the date of the posting of the, about the next date of the posting of the.
Seal number 96.
I appear for the
Abhishek
respondent.
Patil.
Withdrawal
90.
was not permitted on an earlier order. Because various issues had to be heard by this honorable court, my lords. So on an earlier order, the withdrawal was not permitted. It has again come for withdrawal, my lords. There's an order by this honorable court explaining why the petition shall not be allowed for withdrawal. On 20th March 2017,
Not to be allowed to be withdrawn.
not to be allowed to be withdrawn. Para number
What has
6.
happened?
Lords, what has happened is that the matter pertaining to the admissions of the medical students into the medical college.
Yes.
As against the approval of the admission, the medical college had filed a writ petition number 4188899. This was challenged before this honorable court. This honorable court, by virtue of an interim order, my lords, permitted to admit the students. That was challenged by the medical council in the Supreme Court, which was kept in abeyance, my lords. Thereafter, the students again came back to this honorable court for a transfer of the admission to other medical college or to refund the fees. These issues, my lords, were kept on large and it was going on for some time before this honorable court. Finally, my lords, the transfer was not allowed, refund was permitted. And by virtue of refund of the fees, my lords, partially certain amount was repaid. And my lords, while passing the final orders in writ petition number 4611, my lords, on 20th March of 2017, this honorable court at page number 58, writ petition number 4611.
Date, which date you said?
Dated 20th March 2017. In writ petition number 4611, which is a connected matter filed by the students. Page number 58.
They also want to withdraw.
My lords, they didn't want to withdraw, my lords. Petition filed by the students were disposed of, saying that the applications pending in that writ petition shall be tagged along with the main matter of 41899. The lordship may take my lordship.
WP 4611 of 2016 is
That
disposed
is
of.
disposed of, my lords, by virtue of the order dated 20th March 2017. And at page number 58, my lords, in the
Now,
same.
what is the impact of we permitting him to withdraw the writ petition?
My lords, that I will show it to your lordships because the entire observations have been made in page number 58 on that order, my lords. There are 23, 22, 20, 22, 23. Yes. Para 22, page 58 of the order dated 20th March 2017, my lords.
28 September 2015.
20th March of 2017.
March 2015.
There's a civil.
Let us see what is it. There are 22.
Para 22 onwards, my lords.
23.
Mr. Abhishek Malipata, learned counsel for the college, submits that the college may be permitted to withdraw the WP number so and so. For such purpose, he tendered the memo containing that the petitions have become infructuous and they also submitted the respective academic year so and so. He may be permitted. At first, we may find that the petitioners are desirous to withdraw the petition. The court may leniently grant permission. However, it appears that the present matter is not such of kind. The aspect of withdrawal can be considered simpliciter without considering the consequences thereof. As observed earlier, after filing the present petitions on 28/9/2015, interim order came to be passed by this court, whereby the college was permitted to grant provisional permission to the petitioners to conduct the course for the academic year 2015-16, subject to further orders, as may be passed by this court. And the college was also permitted to admit the students, of course, with the clarifications that the admissions are subject to the result of the writ petitions. The fact remains that the pursuant of aforesaid interim order dated 28/9/2015 passed by this honorable court in WP number so and so, about 60 students were granted admission. The fees were collected by the college institution, and they were prosecuting the studies in the proceedings before the apex court. The aforesaid order was kept in abeyance by the apex court. Prima facie, it can be said that the question of collection of fees based on the admission and subsequent non-continuation of study by the student concerned, etc., all have arisen from the orders of this court dated 28/9/2015. It is hardly required to be stated that no litigant should be allowed to earn any premium on account of the orders passed by this court. As it is, if the orders passed by this court are stayed by the apex court, in normal circumstances, a restitution is to follow, which may result to refund of the fees fully. But since it has been contended by the behalf of the college institution that they are entitled to appropriate to or retain 30% of the fees, and refund will be made to an extent of 70%. And when the students have also claimed for the damages, but as a prima facie observations made by this court, the case may be considered only to the extent of interest on compensatory basis. We find that all the aforesaid situations are yet to be examined and to be decided by this court. Withdrawal of WP number 41899 of 900 should not be permitted. Further, at the time of disposal of the WP, the court will have to conclude on the aforesaid aspects which have originated from the orders of this court, and therefore it could be expected for the court to adjudicate the redress the situation arising on account of the interim order passed by this one. What is
Pursuant to interim orders, these students,
please, my lords,
your clients,
please.
whether they've completed
No, no.
the course now.
Their course were kept in abeyance, and then the Supreme Court did not permit them to transfer to the other college as well. So, my lords, the course which was they undertook to study was cancelled. The fees was paid to the college.
How much fee was paid by each of the students?
My lords, to our calculation, my lords, the set fees was 6 lakhs, 13,000, my lords.
In all?
In all, no, my lords, each student has paid 6 lakhs, 13
That's
students.
what?
About 60 students had paid.
6 lakh 13,000.
6 lakhs, 13,000 each student, including the hostel fee. It's out of which what has happened is 5 lakh 8,000 was deposited before this honorable court by virtue of the orders.
Totally 6 crore 38 lakh.
No, ma'am. 6 lakhs 13,000 for each of the students.
Correct.
Into 60
Totally
students.
Into 60.
60.
That's what we told. Or early 3 lakh 60,000.
67,088. Please, my lords. 3 crores 86, 67 lakhs.
3 crore
67 lakhs and 80,000.
67. 3 crore 67 lakh
80,000, my lords. Out of which, my lords, 3 crore 5,000, 28,000, 5 lakhs 28,000 has been deposited before this honorable court.
Out of this, how much?
3 crore 5 lakh and 28,000, which comes up to 5 lakh 8,800 per student.
Only about
85,000.
80.
85,000 per student, along with the interest is remaining to be adjudicated by this honorable court, my lords.
No, out of 3 crore 67 lakh 87,000, 3 crore 52 lakh 800 has been paid now.
3 crore 5 lakh 28,000.
3 crore 5 lakh 28,000.
Yes.
Yes. Remaining, how much to be paid?
My lords, about 62 lakhs is to be paid.
62.
62 lakhs 52,000. This is excluding the interest as claimed, my lords. This is only the amount which has been paid to the college.
That amount is deposited here.
Please, my lords.
And sent to parking in a interest.
Students, my lords, have out of this 3 crore 5 lakhs, my lords, 5 lakhs 8,000 was deposited in favor of each student.
5 lakh 80,000.
8,000. 5 lakh 8,800.
5 lakh 8,800.
Yes, please, my lords. And out of which 4 lakh 33,000 has been withdrawn by the students, each of the student.
4 lakh
33,000.
They have withdrawn now.
Please, my lords.
What is the remainder?
Remainder is that 85,000 in the, sorry, 75,000 in the deposited amount and
75,800.
800 in the deposited amount and 85,000 of hostel fees, which is yet to be deposited by the college. Please, my lords. This issue, my lords, and along with that, one more IA which we had filed is IA 2 of 18, which is for the interest of the amount which has been taken by the college.
Whether amount was parked in interest earning scheme or not? No. Whatever amount you have parted with, for that interest is to be paid. Generally, how are the patterns of orders in matters like this? There are judgments.
Please, my lords.
How courts have patterned judgments?
I'll place it, my lords, on that issue with respect to the interest. I'll place it for your lordships, my lords. I'll examine that aspect. Lord, since it has come for withdrawal of the matter, I wanted to clarify before your lordships. If it is for final hearing,
Counsel for the petition.
College is not here, my lords. Mr.
not
Abhishek
here.
Mali Patel is not here. But
Was here in another matter today. In this matter, he is not here. He is aware of this order.
Please, much more. He's been the counsel on record from the beginning of this matter.
These are really interesting, but Just give a arithmetical calculation.
Please, my lords.
How much money was paid, how much
My lords,
given to
what,
you.
what they are contending is that,
That should be tabular statement.
please,
They're all arithmetic values. And interest you are asking, you have to give one or two judgments of our high court or some other high court,
Please,
which will give the pattern for us to follow.
I'll place.
Again, date will not be given
No,
for
no, my
pattern
lords.
judgments.
My lords, I'll place
It's an
it.
advocacy.
In the text of the case, memo, the withdrawal is not accepted.
Yes.
Oblige.
Number 97. H.C. Shivram.
Case of non-hearing the matter, my lord, within the particular period. Now they have filed objections, your lordship, saying that they have already
Filed
passed
the
the order.
compliance affidavit, my lords.
Compliance is done now.
Yes, my lords.
What was the order?
My lords, the order was the writ petition to consider the representations of all the stakeholders in the matter and pass an appropriate order in accordance with law. After the order was passed, my lords, all the stakeholders were
They
called for
refer,
an inquiry.
they refer, my lord.
Respondent number 4 in the writ petition has appeared. The present complainant has not made his appearance in any of those inquiry notices, my lords, which was sent.
No inquiry
And-
notice was sent on 21/6/2002, every
Have
hearing, my
produced
lord.
those
My
inquiry
parties,
notices.
Now the order has been, now they have complied. You have to take up on the other
let
side.
them furnish the order sheet, your lordship. Otherwise, you.
That order
we
is at
can't-
page 43, my lords. I passed on a copy to the other side as well.
No, no,
In
order
fact,
sheet, order
what has
sheet
been
means-
suppressed in this matter has been lodged. There has been an injunction which is acting against the complainant, which has been
Yeah.
suppressed from this court, my lords.
No,
From
no,
the
no.
OS, in an OS.
Sanction order is
No,
there.
no, it is always there, your lordship, in when the matter was. I'm sorry,
Please stand.
I'm sorry.
I've secured this. I just have one copy, my lords. In this.
Page
brief-
19,
my lords,
not page 19, page 19 of your,
The order which is passed by our authorities at the page 43, my lords, annexure R4, in the compliance affidavit which I filed today, my lords.
you have filed it today.
Yes, my lords, I'm sorry.
Not reached.
They have not come. When matter is posted today, the practice is that it should be given in the court, not filing there and telling the court we have filed there.
I'm so sorry, my lords.
That's
I
a
should-
sharp practice.
I'm so sorry, my lords. I thought I should file it in the registry for it to be scrutinized. From next time onwards, I'll do that, my lords. But I have a copy of mine. If I
What
may
you
hand
should
it.
do with your copy?
I'm
It's a
sorry.
sharp practice. The Supreme Court said it's a sharp practice.
I apologize for that, my lords.
We'll go
After vacation.
In the meantime, let him furnish the order sheet, your lordship, maintain.
Furnish a copy
Because
of
we
the order
can't get
sheet.
any sheet from the office, my lord, because, please, your lordship.
7th June.
Because they refer 4-5 dates, your lordship. We couldn't get, my lord.
7th June.
After
The
vacation, any day.
presence of the accused may be dispensed.
Give the names.
Yes, ma'am.
Names and designations.
Number 98.
Any date is. Sorry.
It was stated that it was stated by learned counsel would be petitioner that so and so, as well as so and so, the respondents hearing are present in person. He identified them. You stop. Stand over to 7th of June. The personal presence of the respondents, both the respondents who are present here is exempted on the next.
Grateful, ma'am.
Obliged.
I appear for the respondent, my lord.
On the last date of hearing on 2/4, your lordship has directed me to serve the copy of the second source notice to the petitioner, and he refused to accept the second copy, my lord. I filed the counter to this application, my lord. Your lordship may kindly para number 10 of the counter, my lord. It is filed on 8/4.
Have you received the copy?
No, my lord, because on that day, in the last occasion,
Give it now.
on the last,
It is with me,
before,
man.
before that, there is one submission, my.
You
Yes.
take it first, make a
Yes.
submission afterwards. You should not say no to receive.
No, I will not say, my lord. I will be
Receive it
obliged,
first.
my lord.
Take it first, take it, read it, and come back after occasion.
Yes, ma'am.
Otherwise, if you had taken it other day, we'd have taken the matter today possibly.
And this memo, what I have filed, also serve the copy to him, my lord. And the order passed by the disciplinary authority also will serve, my lord.
Give all copies to them.
All the copies I served, my lord.
All right, we remember, good.
Yes, ma'am.
My lord, one submission, my lord.
Had you received copy when they were tendering, we'd have, possibly we'd have heard you. We will not hear you now because it amounts to virtually negating things. You should have taken, subject to its exception. You did not do. Yes, after occasion.
Before that, it is my humble request, my lord.
We also humbly request.
But it is a
Wait.
humble request. Kindly permit me to 2 lines, my
No,
lord.
no, not today. There are many advocates are waiting. Parties can wait. You are from Bangalore.
No, because I
Are you
don't,
from Bangalore?
yes, my lord.
You can come here. No use.
Which date do you want? June 21st.
21/6. Number 99. New petition by foreman.
This is that matter you are.
Yes.
Let us see.
I have one request, Manoj, before my learned friend starts. Senior today is not in town. Let's let my learned friend conclude it today. For our submission, I would request for Thursday.
Then what is the controversy?
I'm sorry. ma'am.
We understand at least with
What
the
is the
help of both
controversy?
of you, what is the controversy?
Yes, yes, please.
Will not conclude the matter.
Not the present review petition is directed against the order passed in WP number 51325 to 51326 at annexure 9 lot, page number 21. In the writ petition, the petitioner sought for quashing an order passed by the Deputy Director of Mines and Geology, as well as the order passed by the Revisional Authority. Now, my lord, the error apparent on the face of the record is, my lord, in para 11 of the order.
Page.
Now, before that, page number 23, para 4, may I take your lordships to page number 23. We accept the
Whether it
contention.
is a forest area or not is the question.
Yes,
What the court came to the conclusion, it is not a forest.
it is not a
Where
forest.
is the material to show it's a forest area?
No, I have, it has been indeed, it has been produced along with the memo during the writ proceedings also. The
Very-
notification itself was produced. And I also produced the very same notification along with an application on 23rd February 2022.
Which declares particular area to be a forest. Which is that notification?
Notification dated 4th March 1936, document number 1, produced along with the application,
You filed it on which date?
on 23rd February 2022. A notification.
Document number 1,
Yes,
4th March 1936.
correct.
That is the
That is
notification.
the notification, which clearly shows
How to identify
Dodda Korategere.
Huh?
Dodda Korategere, first,
Dodda Korategere,
yes, ma'am.
Ulsandra.
Pulasandra. And with survey number also, it is mentioned, area survey number.
But there is Gomal land also.
Global land that has been notified as Korategere Betta Minor Forest Block.
Totally 682 acres, 34 guntas.
Yes,
Totally.
total extent.
Of that 147 plus
85,
85.
yes, and 1, survey number 1.
So 200 acres, 8 guntas, 208 acres, 35 guntas.
We are concerned with blood survey number 16 only.
16.
16.
That is 147 acres.
85 acres, 16 gunta.
Hmm?
85 acres, 16 guntas. Survey number 90 is 147.16.
No, where is the word forest?
Blood in the preamble itself, it is stated. The government of His Highness Maharaj of Mysore are pleased to declare under
Minor forest.
Korategere Betta Minor Forest Block.
This has not been noticed by the benches, your worship.
And in fact, in para 4 of the judgment, may I read.
Para 4 says, question is whether it's a forest land or not. We answer it in the negative, last paragraph.
Last paragraph, placing reliance on the wrong judgment. In the last paragraph, in para number 21, we thus got a judicial pronouncement in relation to said survey number 16 that it was never declared as forest area.
Statement is not correct.
Not that. I have produced that judgment also, my lord. It is in respect of Kadugodi plantation, survey number 1.
Not with regard to the.
Not
this
with
at
regard
all.
to this at all.
There is error apparent on the face of the record. We have adopted order 47 rules 1, 2, 3 of CPC for writ proceedings under rule 39 of writ proceeding rules.
Correct. That's
Is error, even otherwise, error apparent on the face of the record.
As far as 1936 notification is concerned, Manoj, paragraph 11 and 12 Manoj of the order, Manoj takes note of that notification also. Paragraph
No.
11, if Manoj may see.
Not only that, there are 2 errors in the judgment now. The first error, not adverting to this statutory notification.
Yes,
Number
Manoj.
1, this is not notified.
Paragraph 11, Manoj, it is noticed.
Paragraph notice, but not treated.
No,
In
Manoj,
the
there-
reasoning part, at para 4, they refer to some other judgment, which again is irrelevant.
That's
So
fine.
there is error from our part we have committed. whichever
Though
bench
though
can-
it is mentioned in para 11, Lord,
That is not
Before
treated.
adverting to the said notification, it is
Have done.
proceeded, and without adverting to the very notification.
So so Allah will make that submission. Manoj, in spite of Manoj, I contention is Manoj, even though the notification is there, Manoj, that notification per se does not declare it. Manoj, what happens is, Manoj, that notification is issued under the Karnataka Forest Act of 1900. Manoj, under section 35.
Mysore Forest Act.
Mysore Forest Act, under section 35. Manoj, that only enables Manoj, the authority to Manoj,
You want to argue now?
no, Manoj, I will make my submission on Thursday. Manoj, it is only relating to regulation for Manoj, the forest produce as to how it is to be utilized. That, anyway,
No, no.
Manoj,
This
I will-
aspect of the matter is covered by the judgment of the apex court in Godavaram Thermal Path versus Union of India. One judgment covers this aspect. There is a good book I told the other day, that Rutvik Datta and Bhupendra Yadav. Have you got that book? It contains all the
All the
judgments and
judgments,
gist
okay.
also.
Yes, yes.
In one of the judgments, it fits into.
we also,
Your
Manoj, would
question
like
is
to place it
negatived
on-
by the, submission
No,
is
Manoj,
negatived by the apex court. Just look into and
Yes, Mullah.
In your favor.
Interim order, I'm praying
So-
for, Mullah.
Praying.
Because quarrying is going on, not within the notified forest.
May I request Manoj to have it Thursday or so?
Under the new act, 1963 Act, Mullah, this village forest is included within the definition of district forest.
the definition itself.
In the definition itself, the district forests include all the land at the disposal of the government, not included within the limit of any reserved or village forest, nor assigned any survey settlement as free grazing ground or for any other public or communal purposes.
You bring that judgment of the apex court. Apex court has answered it in your favor.
Yes.
There's the latest judgment also, Luton's judgment of Delhi's last month, about 1 month or so. Bring that judgment also, it covers.
Please.
So it goes to two tests. 24th. Yes.
24th.
Yes.
Dispose of the matter.
Please.
24th. Just remind us. We'll take
2:30, Mullah.
2:30.
All right.
Or 2:30.
Obliged.
Fifty-six urgent, seal number 57. Sampath Anand Shetty.
This matter, I'm filing additional affidavit. Mullah. We have complied with the order.
My lords, I just received it some time ago. I'll go through it and.
We have
file
already
my
filed
reply
a
notes.
compliance affidavit, additional affidavit filing.
To consider representation.
Yes.
What is
And
that?
we have treated the president non-judicial member at par with the not judicial member. In para 4, we have stated, Mullah, respondent has been paid the sum of rupees 7,51,485.
It was released to the Hassan District Consumer Dispute
Yes,
Redressal
ma'am.
Commission.
Towards errand leave. This amount has been paid, and my lord, in paragraph 5, we have stated, I respectfully submit that at the time of appointment of the complainant, his pay was fixed at par with the district judge only. And he has drawn the salary which is equivalent to the salary of the district judge for the whole period of 5 years for which he was appointed as a president. So far as extension of second SNJPC is concerned, Lord, we have not extended the same even to the judicial member. Whenever we are
So,
extending the same,
that question will not arise.
will not arise.
If I may make a submission. Their affidavit states,
Paragraph 4, page 2 of the complaint.
They have received money also.
yes, my lords, but we have the refixation of this thing, my lords.
No, that you
It
have
is
to work out
partly
on the
complied,
judicial,
my lords.
in the regular jurisdiction, not in contempt.
My lords, if
And
I
that
may be-
the other benefit, namely, now the second National Judicial Pay Commission, that benefit is not extended to the judges also. Not extended. Therefore, you are also not.
My lords, your- in our complaint, at serial, sorry, page number
So we discovered
40, my
this,
lords,
madam.
refixation of pay is not granted, my lords. My lords, I seek for a short accommodation, my lords. We'll go through the.
No, this is a satisfaction of the court.
My lords, one accommodation, my lords, I request, my lords.
For what?
I'll go through the affidavit, and give a reply, my lords.
Go through right now, paragraph 4 only.
I just received, my lords.
No, your client has received the money. He should have informed to you
My lords, I'll
that I have
seek-
received money.
I'll seek instructions on this and. give
No,
my
if this is
reply, my
false, you
lords.
can agree with it. Otherwise,
My lords, I request for a short accommodation, my lords, next week, my lords.
Day after tomorrow.
Day after tomorrow.
At 2:30.
Yes, my lords, much obliged.
Meeting for 2:30.
Nothing remains.
Number 58, Suraj.
Direction to effect kata in the name of the petitioner as per on the basis of the Akkupatram. Very
Kata.
simple.
Khata verification. Not done. Services to after verification. 4 June.
Number 59,
Apologies, my lord. We'll carry out the amendment today itself and file it in the next 2 days, my lord.
And
If
for
it may
the
be taken up next
respondent,
week, my lord. We'll carry out the amendment today itself, my lord. One implement was allowed. My apologies, my lord. I'll carry it out today itself.
So something is filed or not? Counter is filed?
No, cost title, yes, to amend.
I'll amend it, file it, my lord. My apologies. A week's time may be granted, my lord. Next week, if it may be taken up, my lord.
Amended. 20th June.
Grateful.
number 60. So Prashant Rao, party in person.
public interest litigation, my lord, as regarding removal of abandoned vehicles in the streets of Bangalore and removal of encroachments on the footpath and pavements. The lordships on the previous occasion, my lord, had directed the commissioner to file an affidavit. That has been done, my lord. Regarding removal of abandoned vehicles, my lord. An order was passed by this honorable court. The state government, my lord, the police department has to take action in respect of taking steps to remove the abandoned vehicles.
When are you removing that?
No, my lord, I appear for the BBMP, my lord, that is.
Whose duty it is?
It is the police department, my lord. It's the state
Police
government.
department.
Yes.
Footpaths are to be maintained under the act, which is that section?
No, as regarding the footpaths, my lord, we have filed an affidavit. It's not only about the footpaths, my lord, it's about the vending zones and street vendors also. It's regarding the removal of encroachments on the footpath pavements as well as identification of the vending zones wherein the street vendors can carry on their activities, my lord. This process, my lord, is being done.
Lordship, my humble prayer, Your Lordship. I have two IAs presented before this court. It might be heard, and a court commissioner be appointed to walk with me in the street where I preside now, Your Lordship. It's totally encroached. They have not left spaces, and I've even filed IA 2024. Just around, I've even given a copy to the Learned Council. Your Lordship, I made 10 videos, and Your Lordship may kindly have a look at it. Your Lordship, they have allowed floors up to 10 floors in my own area, in the road, Your Lordship. 10 floor allow madidare. 10 floors, Your Lordship. They're earning revenue. They are earning revenue. All this petition is about safeguarding of footpath, Your Lordship.
Come to page 16.
Yes, my lord.
See that.
Please,
What have you done?
my lord, as regarding this, my lord, I filed a detailed reply to this.
No, we don't want your reply.
No.
What have
Yes,
you
my
done to
lord.
this?
As regarding 16, my lord, it shows the photographs, my lord, wherein footpath bollards are being placed so that vehicles or maybe two-wheelers, my lord,
You only
would
have
not.
put, you only have put them.
Yes, yes. Now this
Vehicles.
Two-wheelers, cyclists or anybody, my lord. My lord, as far as this photograph is concerned, my lord, this is done under the smart city project. And for laying a footpath like this, my lord, the width of the footpath, my lord, must be at least 15 feet width, my lord. Whereas the petitioners, my lord, if your lordships may kindly see, the memo filed by me as on 10/4/2022, I have produced the photographs wherein the petitioner's house is being produced is captured in a photograph. Wherein, my lord, if your lordships may kindly see the petitioner's house, my lord. In front of his house, my lord, this is a footpath cum drain, my lord.
Page number?
Page number 10 of my memo filed on 10/4/2022, my lord.
What happened to the date?
You have not filed objection statement.
I don't.
My lord,
Have you filed objection
no,
statement?
this memo itself has covered
We are
all the
asking you.
aspects, my lord.
Have you filed objection statement?
Statement of objections is not filed, my lord. I've just filed a memo to that effect.
So only produce
Stating-
photo.
No, my lord, I'm just
So to
bringing.
file statement of objection,
Very well, very well, my
traversing each of the paragraphs in the petition, this is
Very
how
well.
we have been taught.
I'll do that, my lord.
Or you don't want to do?
No, my lord, it is not that I don't want to.
Just how much time you are wasting?
You are for whom?
I am for respondent number 2, BBMP, my lord.
My lord, I appear for
State.
the state. My lord, on 8/2/2024, my lords were pleased to pass, my lord, certain orders with regard to removal of abandoned vehicles.
Ah,
My lord, I have received instructions only on Friday. My lord, I'll file an affidavit to the effect with regard to, my lord, the actual, my lord, action taken by the police for removal of these abandoned vehicles. My lord, the direction by my lords was that first we should inform the registered owners with regard to the vehicles. And if they come forward and they pay the penalty amount, then the vehicle is released to them. My lord, the instructions that I have received is there are totally 1,412 abandoned vehicles.
abandoned vehicles.
Yes,
Means
And,
nobody is coming forward to claim them.
no.
Yes, what should be done with
Lord,
regard
out
to
of that, 918 have been unclaimed. We are waiting for the owners to come and take possession. And 494 is pending disposal. My lord, I'll come up on an affidavit if my lord were to grant me some time, my lord, immediately on the reopening. Because there are 50 police
Right, but
stations
you-
throughout Bangalore.
Go to page 15. It is your affidavit?
Page 15.
Or it is a writ petitioner, sir? Writ petition. Where is your affidavit? So the photographs must have been produced with something. Where, yes. In what way photographs are produced?
My lord, my memo dated 10/4/2022, my lord.
Your affidavit is there.
It's a memo, my lord, wherein I produced the photographs.
All, most of the panel advocates are substandard. Therefore, it happens.
Where are your
They are
photographs?
appointed based upon all
Where are your
extraneous
photographs?
considerations.
Where are your photographs produced?
My lord, in my memo, my lord,
Where is that page?
at page number, my memo is dated 10/4/2022, my lord.
We will not tolerate for producing of photographs in such a manner and wasting court's time.
My
Let
lord,
us
I'll
see
be
in what
filing a
way you are
detailed
produced.
statement of objections. I will be filing, my lord, along with all the material which I have been placed, along with the memo, my lord.
Not come.
No, they do not file. Minimum rules of pleadings, rules of PIL jurisdiction.
So
Nothing.
photographs are, where is your photograph?
Never they read. All
We want to see your photographs. Put up day after tomorrow at 2:30.
Your Lordship, my humble prayer.
Your presence is not necessary.
You have brought it, it's over.
We want to see the manner of your producing photographs. You can't throw the papers like that.
My lord, if I just make a mention.
No,
my
we'll
lord.
see, we're not commenting anything. We'll see first how, in what way you produced. Day after tomorrow.
This memo, my lord, was initially filed in the writ petition wherein it was, my lord, before the single bench. Subsequently, my lord, it was converted into a.
Let me see at least what is the way you are producing. Day after.
Appreciate it, Lordship.
If you want to remain present, you are welcome.
To be present, Your Lordship.
Most of the panel advocates are appointed. extremely
Kindly pardon me, Your Lordship.
So we have this difficulty. Caste or political affiliation, these are the basis. They never read. In PIL affidavit is a must. The first year law student should know these things.
My apologies, my lord, I will.
What kind of panel advocates we have? Does anybody turns the pages of the law book?
No, my lord.
In the 80s, the Supreme Court said in every PIL, once notice is issued, affidavit should be filed.
Please, ma'am.
All extraneous considerations for appointment. This happens.
My lord, may I just state, my lord, this was a
Right on.
writ petition, my lord, which was filed before the single
down.
bench.
18/4/230. December 61.
We appear
Arun
for
BM.
Petitioner in this matter, medical admission matter, I have filed an amendment application to demonstrate what fraud was played by the
I'll file objection to that, my lord. Lordships may
No,
grant me small time.
my lords, medical.
Amendment application is filed at this belated stage. I at least need some
They have
time. to
played
review
fraud
it.
on the Supreme Court had directed to reconsider the matter. In spite of the Supreme Court directions, my name is not included by the committee. They have considered that and placed before the division bench. The division bench, not noticing that my name was not there, passes an order. Now I have demonstrated fraud was played on this honorable court and circumvent the orders of the honorable Supreme Court. I have placed only the documents furnished under RTI to demonstrate the fraud played by the parties on the, I am not, my lords, one thing I want to make it clear, my lords, in so far as the seventh respondent is concerned, who has got admission, I am not playing. The Karnataka Examination Authority is at fault, my lord. Some action has to be taken in this matter. The girl, for 2 years, no admission is given. Now, in 2020, on a reference, I'll pass on this judgment, my lords. Supreme Court has directed all the high courts how to deal with these matters when admission is wrongly deprived.
Lord, as long as my admission is not disturbed, I have no qualms with him, Lord.
No,
If
I
he
will not
says-
say that. I'll leave it to the honorable court. I will not seek for setting aside his admission, my lords. The student.
You have filed application now.
Yes, my lords. Amendment. Yes.
Amendment. When
Kindly
have-
see the directions of the Supreme Court on a reference in these matters, my
When
lords.
have you filed the application?
I have filed the application on 28/3/2024, my lords. It's put up.
Then 2 weeks they have got.
No, I will
adjournments
not,
to pay the file the
ಅಲ್ಲ,
objection.
objections ಅದಕ್ಕಲ್ಲ, documents produce ಮಾಡಿದ್ದೇನೆ ಅಷ್ಟೇ. I have not said anything in the matter.
Lord, recently, Lord.
This is all within their knowledge, my lords.
No, no, this. he
And
says, my lord,
what
fraud
they
is
pleaded
played.
before the division bench was, since there was delay in disposing of the matters, I am not entitled to any relief. My lords, that is, that they pleaded in the earlier writ petition.
If the,
You have filed application.
Yes.
On 28 March.
Please, my lord.
Under the writ proceeding rules, where we have adopted CPC, it gives 14 days to file objections. You permit him because you have made some, maybe wild allegations, maybe true also, we do not know.
Please.
Let him come up with his or
I will not.
so that we can,
Grateful.
otherwise it will be one side will be
ಹೌದು,
decided. That's the
I
reason.
understand.
Some serious objections are taken by your client, na?
The only thing is, Supreme Court has said priority has to be given to these matters.
Correct.
ಅಷ್ಟೇ, ಅದಕ್ಕೆ, otherwise.
2 years have
I will
elapsed,
not.
my lord, and.
Next week, any date in the next week, I will request the court.
2 weeks
5th
maybe
May,
not.
the NET starts, exams are there, 5th May. One seat has to be reserved to this student in accordance with these directions.
Is, Lord, the.
Supreme Court
admission-
directions.
admission
One
is
seat
of-
has to be reserved in the next year.
Yeah, my lord. 2022 is the period in question. In 2022, about 6 writ petitions have come to be filed. I have also, my lord, enlisted, my learned friend is, my lord, more than fair.
Oh, if he
In
argues
enlisting
on main,
all the
I will
writ
also-
petitions, my lord, that are filed. There is only, yes, my
But do you want to file objections or you want to argue?
no, no, I know, my lord, I don't want to argue. I don't want to.
waste time.
I'm so sorry. 2 weeks' time may be granted, my lord, to file objections. That's all.
So. My lords,
But
they
you
are-
are
if it-
seeking admission for the year 22-23.
That's what I'm saying.
now they have played fraud on this court and the Honorable Supreme Court's orders are circumvented. I'll demonstrate in 10 minutes, my lords. I will not take much time. Supreme Court said, even if there is delay in my matter, it has to be reconsidered. That order was militated by the Karnataka Examination Authority with impunity. I'll demonstrate, my lord. The director, now Principal Secretary has passed an order based on the Law Department's opinion that there is a fraud played, give him admission to me. Principal Secretary's order is not implemented. Please, my lord.
He is enjoying an interim order.
No,
No, my lord.
no, my lords.
There is
I am
no
a- I am not-
interim order.
I have not
6
got
writ
admission.
petitions are filed. Matter is of 2 years have elapsed. That's what I'm saying.
No, kindly
I'm
see
not
the
arguing the
directions in
matter.
this court in 2020. This was not brought to the notice of the earlier division bench. The Supreme Court has issued directions to the high courts. Kindly see this direction,
Writ petition.
please.
Writ petition is of the year 2023.
What should be happen in these matters if I am entitled for a relief? Your lordship may
Copy
kindly.
may be.
I'll say, sir.
Thank you.
Your lordship may kindly see the reference at para 1. I'll only read 2 paragraphs in this matter, my lords. This is a 3-judge bench judgment.
Paragraph?
Paragraph number 1 may kindly be seen. The issue that arises for consideration is whether a student, a meritorious candidate for no fault of his, her, and who has pursued his or legal right expeditiously without delay, can be denied admission as a relief because the cutoff date of 30th September has passed. In such a situation, the relief which can be given by the court is to grant appropriate compensation only, question mark. Third paragraph, my lords. At the outset, it is required to be noted that in the present case, in spite of submitting the necessary material in support of the claim of the appellant for reservation in sports and games category for admission into MBBS course, she was denied due priority in admission into MBBS course. Therefore, the appellant immediately approached the High Court seeking admission in the reserved quota of sports and games category. Identical circumstances, my lords. However, it was found at the time the petition was heard, the academic session for the year in question had already commenced from 1/9/2015. And as per the decision of this court, the last date for admission would be 30/9/2015. The High Court, considering the decision of this court in Jasmine Kaur, observed that no direction can be issued to the appellant for grant of admission for academic session 2015-16. However, relying upon the decision of this court in Jasmine Kaur, the High Court granted compensation of 5 lakhs. Your Lordship may kindly turn to para 13. After considering all the case law, kindly turn to para 13. This is the directions issued by the Honorable Supreme Court. In the light of the discussion observations made here and above, a meritorious candidate student who has been denied an admission in MBBS course illegally or irrationally by the authorities for no fault of his or her, and who has approached the court in time and so as to see that such a meritorious candidate may not have to suffer for no fault of his or her, we answer the reference as hereunder. 13.1 is relevant, my lords, that in a case where candidate students has approached the court at the earliest and without any delay, and the question is with respect to the admission in medical course, all efforts should be made by the court concerned to dispose of the proceedings by giving priority and at the earliest. 13.2, I don't come because cutoff date is over. Now kindly come to 13.3 in my situation. 13.2 is not applicable to me because I have not, cutoff date is over. In case the court is of the opinion that no relief of admission can be granted to such a candidate in the very academic year, and wherever it finds that the action of the authorities has been arbitrary and in breach of rules and regulations of the prospectus affecting the rights of the students, and that the candidate is found to be meritorious and such candidate student has approached the court at the earliest, and without any delay, the court can mount the relief and direct the admission to be granted. So such a candidate in the next academic year by issuing appropriate directions by directing to increase in the number of seats as may be considered appropriate in the case. In case of such an immutuality, and if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case, the court may direct to reduce the number of seats in the management quota of that year, meaning thereby the students who are denied admission illegally to be accommodated in the next academic year out of the seats allotted in the management quota. Then 13.4, grant of compensation could be an additional remedy, but not a substitute for restitutional remedies. Therefore, in an appropriate case, the court may award the compensation to such a meritorious candidate who, for no fault of his, has to lose one full academic year and who could not be granted any relief of admission in the same academic year. Well, thereafterwards, this was carried to PG admissions also. And now the Honorable Chief Justice has passed an order in another case. I will place it on record during arguments. This paragraph 12 and 12.1 and 12 are amplified by the Honorable Chief Justice in the latest judgment of restitution in Kerala matters.
Which is the course you are seeking?
MBBS, my lords.
MBBS.
Please.
Yeah.
Very sad state of affairs of this girl, my lords.
So your submission is in the event in that academic year, no seat can be allotted. It can be given in the next academic.
Please, my lords. Now the principal secretary says, I am P4, he is P5. You have played fraud on him, the girl, the petitioner, in not granting admission. The director of the Karnataka Examination Authority says, you may be wrong to the chief principal secretary. Kindly verify. Then principal secretary sends the file to the law department. Law department says, yes, that girl is deprived of her seat. She is P4 in sports, national champion. He is only a participant. Then the law department compliance of that is sought by the principal secretary medical education based on the Supreme Court orders. They are not complying with that examination authority first respondent.
You are another student.
Yes, in fact, Lord.
Who appears for the examination authority?
Mr. Ramesh appears, Lord. Just for responding, Lord, what my
For
Lord.
the authority.
No. I am for the respondent, Lord. He says.
No, student, he is for the
student.
Every
Yes.
year there is a different quota or same?
In fact, my Lord, already my learned friend approached this honorable court in 2023. Writ petition was dismissed. The Honorable Supreme Court also confirms that order.
That is
My
contrary.
learned friend, my Lord, has produced them. It is, my Lord, I think fourth or fifth round of. It is.
I am not interested in disturbing his admission.
Yes,
If my learned friend argues on merit, he'll get into difficulty in the matter.
No, no.
He's entered wrongly.
Want a seat.
Please, my lords.
And you agree that as long as his apple cart will not be disturbed.
I'll go.
If you are given a seat.
Please,
That's
my lord.
what-
Yes, I will go away, my lord, if my.
That's all argument.
And for that, I have to demonstrate that there was no, I have delay on my part.
I approached the Honorable Supreme Court, my lord. Honorable Supreme Court says, if I am qualified on merits, even otherwise, rehearse this sports quota, my quota should not be disturbed. The Honorable Supreme Court has said. So, my lord, in compliance of the Honorable Supreme Court's order, if my learned friend undertakes or my lord KE undertakes that my seat will not be disturbed, I will be away.
That paragraph.
Yes.
13.3.
Yes.
Of the judgment. It permits making addition to the quota.
Correct. That is 2 years have elapsed. Yes, supernumerical quota can be created. Supernumerical quota can be created. So as long as 2 years I have already studied and Honorable Supreme Court, sorry.
We do not understand the logic of your argument. He says, you need not be disturbed. That should end your argument.
Yes, ma'am. It shouldn't. I bow down.
As a student.
You want to argue?
No, no, I don't want to argue.
As a student and as an officer of the court, it's not fair, my lord's youngster, he has got a
He has
seat.
to protect the interest
Allah,
of his
I'll-
client. He is protecting. Anyway, I have said that.
Yes.
The concerned, who, Mr. Ramesh.
Yes.
Have you seen this 2020 judgment of 3 judges, 3-judge bench? It makes a marked variation from the earlier pattern of
13.3.
judgments. All through Apex Court said, you are not supposed to
Yes,
add even
from
one
one-
single seat to the
Yes,
matrix
that is there. From one academic year to another academic year, no, we cannot allowed.
at all. But now they see the judgment. There is a tangential development.
On reference.
Paragraph
13.3, ma'am, I've shown to.
13.3. Supernumerary seat can be created. And if injustice is done to a particular student, and if a seat cannot be granted in that particular academic year,
For the next
it can be
academic-
passed over to the next.
But for this, my lord, in the context of medical education, my lord, the NMC, all my lord, have to agree for that.
But for that, you have to come out with your stand.
Yes, ma'am. I will, only thing is.
Go through and.
Go through and.
Yes, ma'am, I'll just go.
But I may be absolved of your submission.
He has filed application. Share one full set of copies so that
I've
again
given
time will
copies.
not be taken.
Allah, I've given copies long back.
As long as my seat is not disturbed,
Sure.
I should be kept away from.
Yes, sir.
Because now if that is his contention, supernumerical quota, then I should be
Then
absolved.
he
That's
is
what
not.
I should be not allowed to.
You will be protected.
That
Way, because we cannot disturb
Great.
another student.
2
for that.
years have
2
not-
years have already
Oh,
done.
okay, that is my anxiety.
No, no,
not that-
that's all. You can have anxiety, but judges are supposed not to have. Right.
Great.
That
If
could be
that is
protected.
recorded, my lord, I'll please.
So that could be protected also, madam.
Yes,
I have
if
no-
that could be recorded.
But
I
how
have
to
to-
give relief to the
Let us-
petitioner, my lord, we'll have to, I'll see, my lord.
Otherwise, my lord, I will also have to argue on merits. That is.
Examination authority has to comply with the directions of the principal secretary,
This is
medical
for
education.
next academic year.
Next academic year.
Next
When the
Once,
next academic year begins.
the November or December, my lords.
Ah.
The dates are, no, not that, my lords. What they have said is, I have not argued the matter on time in the court. Last time they made submissions and my matter was dismissed.
No, you have argued very vociferously. Everybody agrees.
Can anybody say that?
Nobody.
Allah, Allah, last, now, I was not appearing earlier, my lords, they have said that before the earlier division bench.
No, we
No.
were not.
He was not there.
He was not there. The
We have
advocate was.
protected interest, my lord, of the earlier.
Other
counsel
advocate
also.
was.
We have
No,
never-
some accommodation before vacation. Let them verify and make submission, my lords.
But in
Next
the-
week,
In the relevant academic year, we did not apply within time.
I applied within time.
Neat
My lords, I went to Supreme Court. Kindly see the only one order I will demonstrate, my lords.
Anyway, immediately after vacation.
After vacation.
My lords,
After your arguments.
Allah,
so
the
that we
Supreme
can-
Court order in my case.
That's what.
Supreme Court said, even if delay is there, I should be granted admission on reconsideration. That was not done.
The question of giving seat in the next year arises only in such circumstance.
Anxiety,
13, paragraph 13.
Howdu.
3 years.
13.3.
3.
Your lordship may make it clear before, immediately after vacation,
It is
otherwise.
for 2 years, that is for 1 year, next
may
year.
be.
This is next, the
La-
year after next.
Year after.
5th of June. we
Fifth
have.
June, please.
Great.
62 urgent, seal number 63. Mr. Srinivas PP.
In this case, my lord.
Preparing for the.
Notice.
Submitted, Srinivas.
Yes, my lord. 4 to 6, it has to be served.
Their endorsement.
Please.
Awaiting for the fees. So, June, 20th June.
Number 64. Chaitanya Hegde.
Would have to take steps for two deceased persons.
Steps to be taken.
Would I request?
Deceased. 21st June.
Number 65. Elva
For
Venkatesh.
appellant,
And for the second
my lord, in the
respondent,
first matter, the respondent number 1, my lords, withdraws the complaint before the learned jurisdictional court in a Lok Adalat.
Has withdrawn that.
Withdrawn that. My lords, however, the learned single judge, my lords, has directed for investigation, which is impermissible, not so far as.
Who appears for the respondent in the first matter? You are in the second matter.
yes,
Wait,
I
we'll come to
appear
you.
for the respondent number 1.
One, in the first matter. You have withdrawn the complaint.
The complaint was withdrawn, my lords, and later 14/9/2019, my lords, the complaint was withdrawn.
Page 127, my lord.
Then once it is withdrawn, where was the liberty taken for filing it afresh? That's the argument. Therefore, we are asking you, have you withdrawn the complaint?
Yes.
How can
complaint
there
is
be a direction for registering case, conducting investigation
That, my lord, that went unnoticed by the single.
unnoticed?
Lords, Page 123, the direction is at page 27.
in that I was not a party.
Therefore, we are not hearing you in that. We will come to your point.
Yes, ma'am.
So since you have withdrawn the complaint, the question of direction for investigation will not arise.
It also would not survive.
That's why.
Order
It's
is-
not pressing.
No, I am the appellant. Now I am aggrieved by the direction.
Only
of-
two petitions dealt with in by Singh common order.
My lords, this direction was issued in WP 25,552 of 2017. That order has to go
40,
22,000,
555.
25,552. Arising out of crime number 47 of 2017. That has been withdrawn.
only. We are deciding that matter,
Yes,
not
ma'am.
yours. Please decide it.
Because I'm the last of petition, I made a request
They have
clubbing the together.
withdrawn the complaint
Yes.
after compromise.
Yes, ma'am.
Therefore, right,
No, my lord,
very fairly, he
that
says, the learned single judge could not have directed investigation at all. That's the law. That, which is that famous judgment, common cause versus Union of India, where complaint is withdrawn. The court cannot direct investigation because parties have set the things at.
Page 128. 128 is the order sheet of the learned magistrate.
Statement to make, my lords. This complaint was withdrawn, my lords, on an assurance by the accused, my lords. Where, my lords, they were supposed to withdraw complaints which were filed against us, my
can
lords.
work out his
That you have
remedies.
to pursue the remedy, not here.
Very well, my lords.
Not
Then I have to pursue
investigation.
a remedy altogether. Different
you
remedy,
can
I have
do.
a different remedy altogether.
Correct.
That's not be done. At that instance, I was forced to withdraw that complaint.
Post 5
Now,
years
my
back,
lords,
my lords, it has been done.
Now, my lords, that complaint is also not withdrawn and still they are pursuing it, but I have a remedy altogether.
You have a remedy, that you work out.
That's correct. What is the other? What is the other bit?
ಅದೇ ಕೊಡಿ.
Both are connected.
The two crimes, two writ petitions were filed.
Two FIRs.
Two FIRs, two writ petitions filed. In one matter, my lords, we did not bring to the notice of honorable single judge that complaint was withdrawn. I have produced it along with the IA as
Are
additional.
interconnected.
No, my lords, it is not
separate.
interconnected,
Separate.
not separate. Complainants are different.
Then very different. And it was a private company.
It was a private complaint withdrawn. Page 128 is the order sheet of the learned.
Page 148.
128, my lords. Typed copy I have produced. My lords, on the bottom, complainant is present. CC present, filed affidavit along with wakalat and memo to hear. In view of the memo filed, complaint is dismissed as withdrawn, put up before Lok Adalat. Memo is accepted, hence case is closed.
This was not noticed by Learned Single.
Well, it was not brought to his lordship's notice.
Were not brought to
No,
notice of the.
in all fairness, my lords, my apologies. It was not brought to his lordship's notice. I have produced it along with the IA for additional. So to the extent of the direction issued at paragraph 5 in WP, my lords, 25,552 of 2017 has to be.
So what is this further information?
Pardon?
Period of five.
Criminal jurisprudence
Five.
of 50 years.
In view of the judgment in TT Anthony, the case crime,
Not the effect
criminal number
of this order.
17, registered by the by the High Grounds Police.
High Ground Police Station, Bangalore shall be treated as
Be
further
treated as
information.
Further information.
It shall transfer to RT Nagar Police Station, shall be
The complaint
investigated.
which was filed by the respondent in the second matter.
Lord,
they are
virtually
referring
it
the
amounts
complaint
to,
Which is being filed by the respondent in the other matter.
That's all
Even
right.
then,
Even in the first matter, it's covered by Lok Adalat. It's a settlement before the Lok Adalat.
Very well.
Then
It is
where is
not a
the
settlement,
warrant?
my lords, it was only a withdrawal which was.
That
being
is
made.
also treated as settlement by division bench, Justice KL Manjunath and the AV Justice AV Chandrasekhar, where you withdraw the complaint before the Lok Adalat. The division bench said it amounts to settlement.
but then this criminal case number 156 of 17 can go on independently or not?
It has to go independently.
Lord, that I have questioned in a,
That also, yes.
I have questioned it, but so far as now, the effect of the Learned Single Judge's order is, in a closed case, my lords, the investigation will be reopened. Then there is no sanctity for the Lok Adalat which is conducted and accepted by
Not
both.
that.
No.
The other companion.
Yes,
Other, this criminal case 156
yes.
That you have
is
to.
referred to for the purpose of justifying the further investigation, treating it to be a further, that can go on independently.
Independently, in another matter, my lord, that could be considered. For so far as this first matter is concerned, it is closed. So that order has to, first matter has to be, my lords, disposed of in view of this.
First matter.
Second matter.
Second.
25.
This is, his matter is second matter.
No, my lord, this is
First matter.
1568, first matter.
First.
Which one? 2552.
Yes, this is arising out of writ appeal 1568 of 23, where settlement has, he has withdrawn the complaint before the Learned Magistrate.
In this. First matter.
So it is for
Well-
third learned advocate Mr.
Venkatesh Dalwai.
Venkatesh
Dalwai.
Dalwai, and for the petitioner, a learned advocate
Yes, Manjunath.
Manjunath.
For respond number 1.
Manjunath.
File the wakalat today.
To respond, yes. Arise out of common judgment and order of Learned Single Judge dated 7th November 2023. delivered in writ petition number 4263 of 17 and writ petition number 25552 of 17, insofar as it relates to the second writ petition number 25552 of 17. The prayer in the writ petition was
That my lord will find it at page
40.
40 minutes, 40 and 41.
Was to cause the complaint filed by the petitioner, as well as the further proceedings in PCR number 2257 of 17, by setting aside the order dated 18/2/17 pass upon the said private complaint. It was prayed to refer the matter for investigation. Further prayer was made to cause the investigation and the proceedings in crime case number 47 of 17, registered on the basis of FIR dated 23/2/17. Paragraph. Learn a single judge directed that there shall be investigation in the matter. Full stop. The operative portion, which is paragraph 5 of the order, reads as under paragraph 5, page 27 to 28. It was pointed out by learned advocate, the petition by respondent, that the complaint in question was withdrawn in the Lok Adalat on 14/9/19. It was done in the presence of complainant. In view of the memo filed. Full stop. This is Rojka? What is this?
But yes, it's an order sheet. Order sheet
This,
before the
this
learned.
factual position is reflected from the Rojka in PCR number 2257 of 17, recorded by the Court of Learned Fourth Additional Chief Metropolitan Magistrate, Bangalore City, into bracket copy figures at page 125 to 129, annexure H, comma in particular at page 128, bracket over. The aforesaid factual position could not be disputed by learned advocate for the petitioner. In view of above, it is evident that learned single judge committed a manifest error in directing the investigation. The appeal deserves to be allowed by setting aside the side direction. Accordingly, it is allowed. As could be seen, paragraph 5, extracted above, the investigation is directed in light of another criminal case number 156 of 17, registered
56 of 2017.
17. My lord, in this case, it is in crime number 47 of 2017. The present case, 47 of 2017.
well, that is
156 is yours.
One fifty-six is my friend's another matter.
Acha, then there is no connection.
No, it's there. Right, 47.
Same.
Yes.
So we say that this will proceed.
Prime 47 has to.
Prime 47 has to go.
156.17. It is clarified that
Right.
order will not,
This to be crushed.
it is post.
Now the another matter, another writ appeal, I am aggrieved by the 156 of 2007.
Nothing to be mentioned about.
Ah,
what-
nothing to be mentioned.
Nothing to be mentioned.
Nothing
about
to be
what-
mentioned about that.
Appeal is accordingly allowed and the direction to investigate crime number 47 of 17 is
17.
hereby set aside. Direction issued by learned single judge to investigate crime number 47 of 17 is set aside.
Great.
The appeal is allowed.
This is earlier.
Earlier bench, which is now office objections has been raised.
No, if there are two conflicting judgments of the apex court of the same strength, bench strength.
Subsequent judgment. needs to-
Subsequent, whether that rule applies to intra-court appeals also?
Yes.
No, huh?
Yes.
Applies.
Applies.
So we put
lords, interim order with kindly.
Interim order.
Interim order.
Great.
So one of the, that other is disposed of.
Yes,
This is-
very great.
Seal number 66, the Kartikeyan BS.
The appellant in this matter. I have filed this application for including lords, the club. Lords, there are some objections regarding that. Lords, a seal is not forthcoming in the affidavit. Lords, I will comply it, my lord. As regards to.
I'm for the writ petitioner, the beneficiary of the orders of the learned single judge. Lords, the grievance as to the sanctioning of the plan was already a subject matter of litigation before a coordinate bench in writ petition number 40994 of 2002 and also a content proceeding CCC 87 of 2004 in which certain directions were given. The non-compliance of these directions was subject matter of the writ petition. Now, the learned single judge says that since the division bench is already directed in a particular fashion, a different view cannot be taken by the government. What was challenged, my lords, before the learned single judge was only an endorsement issued by the government, which did not accept the resolution passed by the BDA. But now the BDA is in appeal. My entire writ petition was based on a resolution passed by the BDA, which was in my favor. BDA supported my case.
BDA is not a department of the government.
It is not. That's the reason why he said, my lords, BDA's resolution is in my favor. But the government said that we don't want to accept the resolution of the BDA. Therefore, we came before the learned single judge and said that the government has no jurisdiction under the scheme of the Town and Country Planning Act to pass an order of the kind, which the learned single judge favored.
The petition was structured on the basis of your resolution.
Yes.
Yes, my lord.
Which is that resolution?
Lords, it is annexure or
Page number?
Annexure G.
It's in volume 2, page number, internal in page number 473, my lords.
473.
3, yes, my lords, in volume 2.
How you can, under which section the power to pass resolution arises? Which is the provision in
Section,
BDA Act?
Section 17 of the Town and Country Planning Act. Sorry, my apologies. Sorry.
Oh, show us. Have you recalled that resolution?
My lords, the government sent it back to us. So as such, it got cancelled, my lords. So, my lords,
The resolution was passed by the BDA.
please.
Under
First-
that resolution, arguably, some rights, maybe inchoate rights, arose in favor of the writ petitioner.
Please.
Government did something that would destabilize the accrual of rights. That has been set at naught by the learned single judge. That means learned single judge shared the view which you had expressed in your resolution. Therefore, how can you maintain writ appeal is Ravi Shankar's question.
My lords,
Yes.
my instructions are, my lords, the
Huh?
resolution that was sent to the government, the resolution itself, the
Case
resolution.
is as weak as your voice is.
Sorry, my lords. My lords, the resolution clearly mentioned that it is subject to the government's approval, my lords. The resolution clearly stated,
Correct.
please.
Government
We
did
are-
not approve. You had taken the ball up to a particular goalpost.
Yes, my lords,
Then the ball was in the court of the government.
please. My lords. But my lords,
Can you file a challenge that would militate against the substratum of the resolution is the question.
My lords, it did not attain finality for the simple reason, my lords. It was subject to the approval of the government, which the
How you are
government set
agreed?
it aside, which the government set it aside.
No, how you are agreed? If it were government were to reject,
Yes, my lords.
how you, that will come to your aid?
My lords, so per se, my lords, the resolution has been set aside, nullified.
Resolution is set aside.
Yes, my lords.
You want
because
that resolution to be revived in this
resolution-
reappeal?
No, my lords.
Then
It
what
is
is your
now,
cause of
it is, since it is nullified, my lords, we have now again carried out some other further investigations, my lords. And we have found that there are a lot of irregularities and we should not have, issued those resolutions,
Have you?
which is nullified,
Understood.
my lords.
Have you taken any action, steps to rescind the resolution? Which is the power? Power to pass resolution is there.
Yes, my lords.
Power to undo the resolution, which is the provision.
But if I may be granted a day's accommodation, my lords, I'll be able to assist, my lords, because
Things will go on like this only.
tomorrow itself I'll assist, my lords, with this question, my lords,
What
because
is your right?
my lords, it was nullified is what the papers are forthcoming is
Have you
nullified.
rescinded, now that nullification
Per
is
se-
set aside by the
yes.
learned single judge?
Yes, my lords.
You should be more than happy with that because it gave effect to your resolution. Learned single judge gave effect to your resolution.
My lords, it was.
How can you be aggrieved by that?
My lords, it was a chain reaction, my lords. My lords, they are now harping upon the strongest link of the chain and not the weakest link of the chain, my lords.
That always weakest, your BDA cases are weak, always they are comprised of all weakest links, including many panel advocates, we don't want to say, because every time we suffer at the substandard performance of panel advocates. We are asking you which is the section which gives power to pass the resolution. You are not answering. We are asking you which is the provision which gives power to rescind the resolution. You do not answer. And resolution is given effect to by the learned single judge.
Yes, my lords.
Your resolution.
My lord, it was a,
What is your right of appeal?
my submission, my humble submission is, my lords, it was a nullified resolution for which life has now again been given by the learned single judge. But my lords, our instructions are, because those resolutions did not attain.
So the power to
finality-
pass resolution, where is your law book, statute? Read, which section gives you power? 17.
17, my lords.
Read
Control and
17.
control.
No. Resolution is given effect to the judge, learned single judge. They want him appeal. They cannot have locus and locum, both. We have a lot of difficulty. We're very sorry. We keep on repeating. We have a lot of difficulty with panel advocates. Performance is markedly low.
That's my
Cannot
apologies.
put in better language. Anyway, just
That's my apologies. my
see
lords.
how
It was-
private advocates are performing, how panel advocates are performing, how we should work, even in such small matters.
My apologies, my lords. My lords,
You want to
because it was
transpose your-
posted for a. Today it was posted for orders, my lords, so my lords.
BDA, BBA.
Now, how you are aggrieved?
My lords, because
For succeeding
the
before
resolution,
learned.
the resolution itself has been cancelled and we have been asked to reconsider, my lords.
No,
So
no,
as
no.
such,
Read page 65. Petitioner society is declared as being entitled to approval and sanction in the layout
In terms
plan
of your resolution.
submitted by the petitioner to BDA. So your sanction and approval is okay in terms of resolution date 21/12/17 by BDA to the petitioner. And consequently, the impugned government order dated 22/9/20.
They don't have power to, government has no power.
Government has no power under the scheme of the KTCP Act itself, and government is not before the Honorable Court, my lords. They are not agreed by the orders of the learned single judge.
You are arguing for whom?
Lords, I am for the society. Lords, we
Right.
are before, Lords, 1992, the layout was formed. There was one problem. The erstwhile office bearers, they committed the planning in a way that there was a deficit of 2% of the common areas.
Based
which
on
was-
some development regulation.
Yes, my lords. That issue came up for consideration before a coordinate bench. Coordinate bench said, if 2% is deficit,
Then probably government has no role.
no role.
Natural.
That's the reason, that's how judgment is reasoned.
My lords, my instructions are the government have also filed a parallel appeal, my lords, which would
Bill
be.
is filed.
Yes, my lords, it's my instructions, my lords. And that would be tagged along shortly, my lords, is my instructions. They have sent it for the approval to the government, and government has in turn sent an approval, my lords.
Website shows
Which
it
is
is
this
not there.
endorsement of BDA 25 to 21?
Lords, the BDA endorsement says that since the government has communicated to us like this, therefore we are not issuing you a sanctioned plan. That is the endorsement.
Sanction plan is only at the level of the BDA.
At the level of the BDA,
Not go to,
not beyond.
the scheme is like
The
that.
scheme is under section 17 is like that.
My lords, the structure here is, my lords, 1992, they place an plan for approval, my lords. Then subsequently, there have been
You have
3
to- we
revised
have-
plans.
We have raised the questions now.
Yes, my lords.
If you further argue, we'll pass the order. If you want to make research, we'll give time to you. And we'll call Madam Neela's writ appeal also along with this.
My lord, I'll have to
Not there.
verify. I have no information. with
No, he
regard-
says that the
No,
government has
I-
filed.
My lord,
He-
Mr.
Give that number,
Gogi-
so
Mr.
that we
Gogi
can
has
call that
informed-
also.
Gogi has, Mr. Gogi has informed my lords that they have sent it for approval with the government.
If you know
And
the
he-
number, give us.
I shall, my lords. I
I
shall.
think the
assist, my
filing
lords.
is not yet happened. Maybe it's an information of the
It's an
website
information
of
that
the
has been-
Honorable Court shows that
Let
there is
him
only
come
one
with
writ
some-
appeal filed.
You want time?
Please, my lords.
Why?
Lords, I'd come in a.
To understand the order or to make us understand the order?
Lords, it was, I misunderstood the stage, my lords. Sorry, my lords.
Twenty-fourth, 18th June. 18th June.
Please.
Great.
67. Krishna S. Das.
I appear for the respondent.
Here.
This matter was heard for some time by lordship and
There is interim order.
Yes, my lord, that is the
After
reason, my
hearing-
lord.
But after hearing both the party, entry body is granted.
Then you
Lord,
enjoy.
But the
One-
question
one-
is, Lord, whether occupier is entitled notice or not, Lord. Last week, Supreme Court, Lord, differed with the view. The matter was referred to larger bench. It's reported in Lord 2024 too.
Lord, that is not an issue at all, my lord. My
That is the
senior
issue which I
counsel-
raised, my Lord.
After
3000
vacation.
Allah, my only submission, my lord.
That is the
now
issue, my lord.
This
That's
land,
only
one-
the issue.
One submission, my lord. There is inordinate delay of 12 years in completing, after completing the acquisition. Now we are forming the road, my lord. This acquisition, this survey number comes in the middle of the road. Because of the status quo, order, my lord, we are not able to, because rainy season comes in the Mangalore. That is the reason, my lord, because in writ petition also, my lord, they are not the subsequent purchaser. Even
We
2016.
are
they
not
came to-
subsequent purchaser, my Lord.
16, they came to write in this survey number. They have taken possession way back in 2010.
Immediately after vacation.
That's my lord, rainy season ಅಂತ.
My Lord, one submission, my Lord. 2010,
Interim order.
yes.
You want us to vacate it?
Certain facts are not brought to the notice of the court
Yeah, I
before the
also-
learned single judge. I have documents.
After vacation.
One
Yes.
date may be given by immediately after vacation.
12th of June.
Please, madam.
Interim order may be acted.
Interim order shall continue to operate till the next day.
68, 69 are urgent. Seal number 70. These objections along with council submission.
Awaiting service.
This is a matter where 2016 it started and a batch of students of about 149.
English translation to be given.
I follow, but at present, may I only submit that may not be necessary because the learned civil judge, after the matter was disposed of, has passed the orders on IA1 which filed by the students for receiving or refund of the amount which is deposited before this honorable court. The issue is only that much, that the amount which has been deposited before this honorable court at the behest of the petitioner students, and we have said that we have imparted them education for the second year and third year, 2 terms. For that, whatever we have imparted them education, and then thereafter they were transferred to other colleges at the instance of MCI, my lord. So therefore, this, that it is
Identical matter was being debated on the floor of the apex court. Identical, because there were two conflicting, varying views. One saying, even in such circumstance, the college is liable to pay back the entire money to compensate, plus something amount.
That's
One
Sarvapalli
view.
Radhakrishnan.
The other view is, even there, the college spends lot of money, therefore, entire money need not be paid back, some apportionment can be done. That is referred to larger bench. Therefore, we will wait till.
my lord, till then, let them not withdraw the amount, my lord.
Let it remain in the court.
Yes, let it be remain here. Ultimately, my lord,
May I make one submission? My lords, all these students are now appearing for their examination of the post-graduation course. 99%, my lords, hail from the lower strata of society, education, my lords, financially. The money which is in deposit, my lords, was sourced by borrowing money from financial institutions. A second set of fee was paid to the other colleges where the students were transferred for the same year.
Till June, July, so that we will have the benefit of apex courts. Till then you wait.
Please, my lord.
Not the.
I have to bow down, my lords.
That way.
May I make,
Let
may
us
I
come.
seek one indulgence?
Yes.
First
Some date
week
we
of-
can fix.
First week of.
Correct.
my lord,
That
another,
of course, my lords, in Sarvapalli Radhakrishna, that is the university's case, my lords, where the Honorable Apex Court was pleased to impose a fine of 5 crores on them.
my lord, may I submit one correction in what my learned friend said? 16, 17, between June to May, that has been paid. 17, 18 is paid.
He is agreeable.
Yes, my lord.
To your proposal and still you want to argue.
No.
That's,
I just wanted a correction, my lord. That's all. This is only for 18, 19.
Order is operated? No.
There is no order as such.
There is no interim order.
No interim order. First.
Tender to 25th June. After hearing learned counsel for the both the sides, it is provided that there shall be no withdrawal of the amount by the petition, by the respondent, by the
Yeah.
petition,
May I seek,
by the petition.
may I seek one indulgence?
My lord, by the
25th
petitioner students, my lord.
25th
Petitioner Petitioner students.
That's what.
Yes, please. Students, my lord. Yes.
The student.
May I seek on an earlier date?
No, judgment we are sending it because we hope that apex court judgment may.
Please,
Lords,
my lord.
I'm sorry, I'm taking too much of my lord's time. But my lords, here in my respectful submission is the question of apportionment also wouldn't arise. Because my lords, we had approached this honorable court even prior to the commencement of the academic year.
Let us.
Please. My lord, one submission, my lord. There are 80 students who are there, but if he's representing all of them, my lord, let him take notice for them, as well as
But
notice may be
I
ordered
take
on
notice for
MCI.
all students,
Yes, all the students,
All the students.
all students.
please. And
In fact, it was my lord's order. My lords. My lords had come to our rescue.
please, my lord, may I also take out notice on MCI and university, my lord, and other respondents, please.
KT.
Yes, my lord, KT, Mr. KT, and earlier NK Ramesh was appearing for.
Ramesh for KEA.
No, the Rajiv Gandhi University earlier, Rajiv Gandhi University.
Notice will have to go.
Yes, my lord.
My lords, they are, of course, councils are there, my lords.
Notice written.
Notice has to go, my lord.
Which date? 25th June, learned so and so waves accepts notice on behalf of.
Notice on respond number.
Response 1 to 81.
No, 1 to 81, Mr. Shetty will be taking notice, also in other cases.
For the rest,
I take notice for 84 and 85.
Yes, 84 and 85,
Ms. Neela
and
Gaurav.
82, 83, and Rajiv Gandhi University, my lord.
Give the cheat to learn and.
I'll give.
so
I'm
that
sorry, my lord.
It is easier for her.
Please, my lord, notice. I'm grateful. my lord.
Great.
So first notice, then that interim order, and then. To illustrate.
Office objections are there.
I'll comply, my lord. I'll comply. Much obliged, my lord.
71 to 78 are urgent. Syllabus 79. Office objection for second time. Abu Bakar Abdul Qadar, 13%.
Weeks for them.
In all office objection. 2 weeks and 3 weeks respectively. Filling which the appeal or whatever matter will stand dismissed for without reference to or order. 89, 10 days. Because ninth time.
88 minutes. I represent the state in the matter. This is a matter where in Shumaga, a cancer hospital is to be established by the government. The state was successful before the learned single judge, my lords. But by way of an interim order, we are now stopped from putting up any construction.
Non-compliance.
Madilla, I am for the respondent, Madilla. That's
Third
my
time-
grievance.
Third time, my lords, only objection is regarding translation copies. It's almost ready, my lords. I will do it within a week, my lords.
There are 9
One
objections.
last opportunity may be given.
There are 9 objections is what I am told, my lords.
One objection.
ಸ್ವಲ್ಪ urgency there. It's a cancer, 100-bedded cancer hospitals. We are.
Without translation, you will lose.
ಇಲ್ಲ,
the
ಇಲ್ಲ, I'm not, I'm
But other
insisting.
objections are regarding application filed by respondents, not my application.
Earlier date before vacations, if a date, my lord, gives us,
Lords, may I submit, my lord? I have filed the impleading application, my lord.
It is on this application objections, no, not mine, my lords.
My lord, it may be taken up next
is
week,
all.
my lord. Because hospital work has been stopped, my lord.
Interim orders will continue.
Interim order, sir.
Please, ma'am.
My lord, next week, my lord, please.
No.
Because our work has been stopped, my lord, because from 22, our work has been stopped, my lord. 40 laborers are without work, my lord.
50 crores
No
was
fault-
sanctioned.
no fault
We
of
have
ours,
already
we-
put
we are
up
suffering.
structures also that was under construction, my lords. Now we have stopped the construction by virtue of the order.
It is my land, my
Because
lords.
almost all 7 districts, there is no any cancer hospital, my lords, because of which it was established. The amount was
Because of that, they can't build a building on my.
please.
Next.
89 urgent. Number 90. The view matter. Mr. Parameshwaraya, DC. Number 91. To hear before charge. Number 91. Srimati Billayar.
I appear for the petitioner, my lord. My lord. In this matter, petitioners are all working as staff nurses, my lord. They're all staff nurses who've been working for over 15 to 16 years, my lord.
Will go after that. 20.
May I please?
26 June.
We'll call this matter after vacation, Professor.
Sir, there is
Naming
some,
of charge it is.
sir, there is some urgency in the matter because they have given an undertaking to the court that they will regularize our services. Thrice it has happened. Judgment has been delivered one after the other. And in this case also,
Nothing.
Immediately after vacation, short date. It's a regulation of service.
12.
could it be sometime next week if it is not possible to?
12th June.
We know.
No, they have given an undertaking. It is not as if.
Sorry, it's a question of regulation of service, nothing urgent.
Quite right, but we have been exploited for 16 years without being paid salary and other benefits.
12th June. Still number 92. Srimati Purnima Hatti. 92. Number 92.
Good, I am 14% in 92. These matters pertain to dealing R&D.
Make use of mic.
Lord, these matters pertain to assailing RMP 2015. And my petition limits to the area of Rajaji Nagar first R block, whereby a commercial land use is being permitted to the plots in the area which is demarcated as mainly residential areas.
Nothing. 2014 matter.
Revised master plan.
Yes, Madam.
It is PA.
Not PIL.
Earlier, mine was a private litigation. In fact, the learned single judge, after hearing the matter for some time, thought fit that it has to be tagged with the matter at serial number 92, madam. Because
a private litigation.
Yes, madam. But comprehends the area of first R block Rajaji Nagar. Whereas the matter at serial number 92, my lord, it is for the entire plan, my lord, for the entire.
Plan.
Yes,
Plan
madam,
itself.
planned area.
We'll have it after vacation.
Yes, after, yes.
26.
Number 93. Muhammad Iqbal, 14%.
My lord, I appear for response 1 to 8.
My lord, this is regarding protection of burial ground and the graves in survey number 27 of Rudrupatna village, Hassan district, my lord. Every day they leave the cattle for grazing on the graves and they tie the cattle to grave stones. They damage the graves, etc. So the prayer is
burial ground.
Burial grounds, my lord.
My lord, may be called immediately after vacation. My lord. I filed my statement of objection.
You filed?
You're not, you're filed?
Yes, my lord.
10.
'94 urgent, still number 95. Mr. Murugesh V. Charity.
This matter, the learned video advocate has tagged on with other connected matters on the other day. My matter is also factually, it is totally different, distinct, because 37 guntas of land. Notification is of their 1977. No award is passed, not, no position is taken. Now it is a developed area in Karnataka in Bangalore. Developed residential area. Learned single judge has observed all these facts and.
Quashed
quashed
preliminary
the
notification.
Notification.
But in the meanwhile, it is entirely developed.
It is developed, fully developed. 37 meters is fully developed residential area.
Fits into that, which is that judgment, Justice Kumar's judgment, famous judgment is there, no?
Learned only Shivana's matter. On the other day, my learned friend who appears for the BDA has quoted this Shivana matter and this Honorable Court tagged on this matter with the Shivana matter, where the Lordship Justice Dadan N. Kumar and Surya Appara has passed. My learned friend.
Under the law, it lapses after 10 years.
5 years.
5 years.
But they have not required. Only preliminary notification.
They are not sufficient.
On the other day, learned advocate to appear for the BDA has referred this. matter.
Junjamma.
Junjamma is.
For the revenue sites and other
Revenue
things,
sites
but
is
this is
Junjamma.
different.
This is BDA. That's how this matter has been tagged on with those. This is actually different and distinct, my lord. So a date may be given in the first or second week so that I can assist the Honorable Court for disposal.
14th.
Please, ma'am. I'm obliged, ma'am.